New conservation. I think listing of one RFC for withdrawal. Video.
ID?
Yes, I'm praying for listing of two motion items for CRP IO Monday.
Why Monday?
Next Monday. I'm led by Mr. Singh in this.
Why?
Motion.
Understood. Why?
There is urgency. The proceeding is fixed before the trial court.
When?
First week of May and first week of May.
So, if you file it, obviously it will come.
No, we have filed it.
We'll take it up today.
It's not yet registered.
Don't mention that. You are not ready to do the matter, don't mention.
On
Try your
Wednesday,
luck with the rate.
or on Wednesday next week.
No. I'm giving you today. You are not ready.
Mr. Singh is to appear in the matter. I'm not. Mr. Singh is to argue in this matter. He will be coming on Monday. Monday or Wednesday, any day.
No. You pick it up with the registry. Registry will list it. Why should I give it today on Wednesday? List it on Monday. Unless there is anything shown that you cannot, you have already filed it. Why won't the matter come up? Tell me. There's no good reason for that.
I pay for listing an IA application. Yesterday it was listed, but not yet.
Yesterday it was listed for what?
Order, but the correspondent has constructed over the disputed claim. That's why we have filed an IA application. Already in RSA, there is a stay order, but they have started construction.
Friday. Same matter.
For orders, my lord.
Why?
My lord, it was numbered, but it is not listed.
IA.
IA, my lord. 129, my lord, not 4.
No, please, Lordship. No, sir, Bextor mentioned listing to CRP IO, Lordship.
When?
Any date, Lordship.
Okay. Wednesday, next Wednesday.
Obliged, Lord.
Yes.
Look, we have filed, my lord, this petition, my lord, for transferring the title suit, my lord, filed by the husband for seeking divorce from Kuprajar to my lord Guwahati.
Why?
Lord,
Why are you in Guwahati?
Lord, he has been driven out from the husband's house, my lord. Thereafter, he stayed few days along with her mother. Now, my lord, she is staying at Guwahati, my lord, along with his child.
So tomorrow you may again go to Gwalpara.
There is no sound because, my lord, she has no other alternative, my lord.
Where was the marriage taken place?
Marriage, my lord, 2004, my lord. 2004.
Where?
At Gwalpara. At Gwalpara.
Where did you last reside?
Last reside, my lord, at the house of husband, my lord, Kuprajar.
And
then husband driven her out, my lord.
when did you start living in Guwahati?
My lord, he has been driven out in September 2023.
And when was the divorce petition filed?
December 23.
And from when you have been residing at Guwahati?
My lord, Guwahati, my lord, since last 2 months, my lord.
Then?
And
Then tell me on what
notice,
basis I transfer the matter to Guwahati.
Yes, my lord. She is now, my lord, staying at Guwahati. And
tomorrow you may say that okay, let me go to Tinsukia. No, that is the question. Because you see the three reasons, 3 points for the conferring the jurisdiction are where a marriage took place, that is at Gwalpara. Second, the marriage had the last together, husband's house at Kukrajar. And the third is at a time when you were staying, it was at Gwalpara. Then how do I transfer it to a court which has no jurisdiction.
Present, my lord, presently, my lord.
Presently, that is why the word presently in bold and capital letters you have put it out there. Makes it very clear.
Because there is no hope, my lord.
When is the next date fixed?
29th of this month. my lord. Days 23, my lord.
Oh, this is a civil.
Divorce petition, my lord.
Then lawyer can appear. Muslim divorce case.
Muslim divorce.
Then-
case.
It is before the civil judge.
Okay.
No ground. Family court, it's a different aspect. I think here you'll get a cheaper lawyer there in Kokrajhar. Or it is because of you.
No,
Then you wanted it in Guwahati. You see, if it is in Guwahati, it has to be given in the civil court out here.
no, my lord, family court. has
How
the-
can it go to the family court?
Because, my lord, where,
It's a
my lord-
Muslim marriage.
no, where the, my lord, family court, my lord, established, my lord, all jurisdiction of civil judges, my lord, vested in the civil family court. Where there is no family court, civil court, my lord, has the jurisdiction.
Then here you won't get the expertise of a lawyer.
In the,
So better you get an expertise of the lawyer there. I'll issue only notice, nothing more than that. Let's see what happens on the other side. If both of you agree, then only I'll transfer. I'm not going to no stay business here. You file your written statement. You appeared on that date. Again, take time. 90 days is there.
Okay.
Then there is one lawyer named M.U. Mondal who is appearing.
he, my lord,
Mojidul Islam.
without Okalatna, my lord, he filed application that we have received someone, my lord, that information was given.
So then,
My lord, there is a risk of her, because she was assaulted, my lord.
she doesn't need to go there. It's before the civil court.
If it ends.
Okay, only issue notice. Making it returnable on 27. Steps by way of registered as well as usual.
In, notice on interim.
That is what I said, no interim. No, okay. Notice. Yes, what is this LIC business?
Lord, I like to be guided by your lordship.
Hmm?
I like to be guided by your lordship. My lord,
What?
two of the documents
Hmm.
which, my lord, could not be reduced earlier, we filed an application. Because it will have a great bearing in the case. That was rejected, my lord, and because of that, we are before your lord. Those documents, my lord, these are. These are the two documents, my lord, will find. One is EMI and one is default burden.
Why the order says, be that as it may, plaintiff has not made it clear what document he wants
Yes,
to use.
is correct, ma'am.
Then
Because those documents were what to have been, my lord, furnished before the court, but that was not given.
Pune with it. Yes, And what has happened to the suit now?
Suit is, my lord, is going on, it's big for argument.
Arguments. Then why have you approached this after 7 months?
My lord, I'll just, will try to persuade your lordship,
Uh,
decision of this honorable court, My lord,
that today is the date fixed for argument in connection with the aforementioned suit. Due to oversight, plaintiff could not exhibit two documents. Then
my lord, your lordship can see one thing. This is a public money. And the person, my lord, he has taken,
what is? I hope the suit has not yet been disposed of.
no, it's pending. My lord, they are not going to be prejudiced by it.
Hmm?
They are not going to be prejudiced by it, but your lordship can say how much they have paid in the meantime, only.
You file a review against that. Well, the reason why it has been rejected is on that ground. This court is not going to interfere with this type of orders. 227, no.
My lord, I understand the anxiety of your lordship. Your lordship may even observation that we can find it. I think that will suffice the purpose.
You withdraw.
My lord, your lordship will give an observation.
This is an application under Article 227 of the Constitution, challenging the order dated 21/8/2023, passed entitled suit number 97/2015, whereby the application filed under section 151, being petition number 1095/920, was rejected by the learned trial court, assigning the reason that the plaintiff did not assigning the reason that the suit was fixed, that the cross-examination of the plaintiff has already been over, and the plaintiff did not assign any and did not mention as to what documents he wanted to adduce and the relevance thereof. This court, having taken note of the said order dated 21/8/2023, as well as also having taken note of, as well as also the application filed under section 151, is of the opinion that this is not a fit case for exercising the jurisdiction under Article 227 of the Constitution. Accordingly, this court dismisses the instant application. Be that as it may, this court is further of the opinion that for the ends of justice, further of the opinion that the dismissal of the instant application shall not preclude the petitioner, who is the defendant, plaintiff, who is the plaintiff in the suit, to file an appropriate application before the learned trial court, giving further details as regards the said documents, and the dismissal of the instant application shall not prejudice the petitioner in doing so. It is, however, made clear that the leave so granted herein shall not apply if the suit has already been disposed of.
Much of.
Yes, what has happened?
That's what my lord, my assisting me in this case, my.
Hmm.
I think there is some order which has been passed.
No, he has filed an affidavit.
We have filed it.
So now he says that he has already withdrawn the surface proceedings.
Then my lord.
So nothing remains.
Withdrawn, then my lord, they can proceed in accordance with law.
So nothing remains out
Yes.
here in view of the
Our whole case
affidavit.
was against that only.
Only. Here you see page 97.
Yes.
That is the affidavit on 23/2024, that document. Last time they produced the document,
I
I've asked them
right,
to put
right.
it by way of an affidavit. So in view of this, that now they having withdrawn.
But they will proceed in accordance with law so far. Yes.
This court heard Mr. Didas, the learned senior counsel, and Mr. S. For the petitioner, and Mr. S. Learned senior counsel appearing on behalf of the respondent number 2 and 3. Pusto. The instant proceedings was initiated on the ground that two simultaneous proceedings were going on in respect to the same property. One was a property, one was a proceedings under the Surface Act, whereby the property was attached by the respondent number 2 and 3 by exercising the powers under the said enactment. The other was recovery proceedings before the recovery officer of the DRT. This court, by an order dated 4/3/2024, by the detailed order dated 4/3/2024, inquired as to whether the respondent number 2 further wishes to proceed with the proceedings under the Surface Act or under the or before the recovery officer of the DRT. Pursuant thereto, affidavits have been filed. Thereby electing, affidavit has been filed by the respondent number 2, thereby electing to only proceed before the recovery officer of the DRT. This court has also taken note of the affidavit filed by the respondent number 2 on 27/3/2024, wherein a document dated 23/2024 has been enclosed, stating inter alia that the respondent number 2 have withdrawn the proceedings under the Surface Act and requested the cooperation of the petitioner in facilitating the return of the physical possession which was undertaken as per the Surface Action. Taking into account the above development, more particularly the communication dated 23/2024, the petitioner, this court is of the opinion that there is no hindrance on the part of the recovery officer of the DRT to proceed with the recovery proceedings in accordance with law. Accordingly, in view of the said development, nothing further survives to be adjudicated in the instant proceedings, for which the same stands closed. Interim orders, if any, stands vacant.
Obliged.
Now, court.
Mr. Doctor, one thing, just you have been doing the insurance thing. The 2022 amendment to the Central Motor Vehicle Rules, the Fifth Amendment, that has been notified
Yes.
from 1st of April 2022.
Right.
Now, that stipulates a procedure or a method by which the adjudication is to be carried out in the MSCT tribunals.
Yes.
More particularly, Annexure 13 stipulates the detailing in which it is to be done. Is it being carried out now?
Not very difficult to say. I'll have to get the idea whether it's being.
Because now what happens, that is why 166(3) has been brought in,
Yes.
making it the limit, making the limitation within 6 months.
Yes.
The reason is being that if there is an accident, within 48 hours, the police has to intimate the tribunal.
Right.
The tribunal will then thereupon give a particular detailing to the insurer, the insurance company, as well as to the owner and all about this thing. Now, thereupon, within 90 days, the entire investigation has to be completed, including the report has also to be submitted under 173 within 90 days or 60 days. I
60.
think that is 60 days. And the DAR, that is the detailed accident report, has to be submitted by the police
Before the tribunal.
to the tribunal.
Yeah.
And the tribunal will thereupon register the claim on the basis thereof. And if there is any additional claim, the claim petition as well as the DAR will merge. That is the basic idea which
Right.
is it. Just find out whether it has been done or not.
What I understand, my lord, these are only in the statute book, but hardly, my lord, the police knows all these things and they don't like to know.
No. I have now, we have seen certain electronic filing. Because I am taking up that issue
Well.
on administrative side. The question is if it is done or not, because then you are also aware about the challenge being made to 166(3)
Once, yes,
of the 6 months.
Right.
Now the that aspect has only been brought in because of this procedure being meted out.
Yes.
That irrespective of filing or not, if you see Annexure 13 now there, it categorically says that the registration of the claim proceedings on the basis of the DAR would be done subsequent to the claimants being brought in. Subsequent to that, it will be duly intimated or not. But once the DAR has already been there, the limitation ceases.
Yes.
So, and I am told out here that there has been certain filings on the basis there of the DAR. So this is being going on. And now you are also being given that this is the amount which is to be paid, whether you accept or not. If you don't accept, then within 30 days, you have to file this step.
if it is done that way, my lord, it
Hmm.
will be very good for the party as well as for the company.
Not only that, in fact, if you see, as I could see, that it takes care of all the loopholes.
Yes.
It is in fact more beneficial on the part of the insurance company also.
Yes, yes.
Because then you don't have this fake or
Fake petition.
filing of all these things does
Right.
not arise.
As a lordship understand, 75% of the injury cases are fake. And from my experience, I could gather that.
And it also says what are the documents which will be required to be submitted.
Right.
So
I'll
just
inquire-
let me
I'll
know.
inquire about this.
Please let me know what is actually being happening, because
Sure.
you are appearing for many insurance company
Right.
as to whether those things are being actually happening out there or not.
Much.
Yes, who is appearing?
My lord,
Tell me, what is this case?
one of the small prayer, my lord, it's
CRPIO, what is it?
40 against the order dated, my lord, at page 56, my lord, by the evidence has been closed.
Both parties are represented. Today is fixed for cross-examination. Learned standing counsel has submitted a seeking adjournment on the ground the witness could not come to the court due to official order. The official order sheet reveals that on Emmanuel fixed as the most large. The duty of the official witness to repose during the official duty and who are you?
Well, I'm the insurance corporation, my employees of insurance corporation. my lord.
Yes, why didn't you go?
And that is my fault, my lord. I
Then-
think our vigilance may not ready give us on official duty, my lord.
Hmm.
And this petition has been filed under section 75, the original petition under the Employee State Insurance Act, being agreed by the order of the demand notice and under section 45 for a sum of rupees 67,000, my lord, for a sum of rupees 67,000. The notice has been issued by the respondent to pay the amount as a principal employer. Being agreed by that,
he has approached the insurance court under section 75 of the Act. And the as per your lordship is aware, the insurance court is equivalent to the civil court. We have filed our written statement, we have filed their evidence, even we have filed our evidence, the originals not be exhibited, the official of the corporation could not be present on the time and on the same date.
So when are you going to be present?
I'll be present on the next date. That is my undertaking.
This is an application under Article 227 of the Constitution. Both the parties are here.
Lordship, I am responding over Lordship.
It is before that court. Okay. This is an application under Article 227 of the Constitution challenging the order dated 27/4/2023, passed in ESI case number 1/2019, whereby the learned, it's a tribunal,
Court, Lordship. Court. It's a
Insurance,
court.
whereby the
23 as well as
whereby the learned employees insurance court, Guwahati, had expunged the evidence of the DW on the ground that the DW failed to appear for cross-examination on the date so fixed. This court have duly heard the learned counsels appearing on behalf of the parties. The learned counsel, Mr. So-and-so, appearing on behalf of the petitioner, submits that on account of official duty which the witness could not excuse himself on that date, he was not in a position to appear before the court. However, he submits that on such date or date, the court fixes, the learned court below fixes the matter, the witness shall be present without fail. This court, having taken note of the said submission and also the materials on the basis of which the said submission have been made, is of the opinion that the said order dated 27/4/2023 requires an interference for the ends of justice. Accordingly, the said order dated 27/4/2023 stands interfered with, thereby directing the learned employees insurance court, Guwahati, to permit the defendant witness to be present on such date as may be fixed by the said court for facing the cross-examination, if any. This court, by an order dated 16/6/2023, had stayed the further proceedings of ESI case number 1/2019, which stands vacated. And as both the parties are present before this court fixes the matter before the learned insurance employees court. Employees insurance court on 6th of May 2000, not on 6th, on 10th of May 2024, on which date both the parties shall appear and the learned employees insurance court shall fix such date as deemed as per its business of the court, thereby fixing the matter for cross-examination of the DW.
And order dated 27/4 as well as 4/5, where we have also filed 27/4/23 the order, as well as the order dated 4/5/23, we have filed a recall petition.
Recall is not necessary, na, because this order, main order goes. Sets aside the order dated 27/4 liquidation report as well as any other consequence. Yes, Mr. Sahu.
Land grabbing proceeding was there.
What?
Land grabbing proceeding.
What are you doing with the land grabbing proceeding?
Now, my lord, the defendant side came with an application to frame preliminary issues. Those issues were heard and decided against me, against that order I have done. My lord. Whereas those issues could not be decided without there being any evidence. My lord. The impugn order is that page 52, my lord.
Page 50?
Issues were 1 and 2, my lord.
Yes.
And to decide these issues, my lord, evidence is required. Because on the basis of facts needed by the defendant, these issues were decided. So for that purpose, my lord, without there being evidence, this cannot be decided. My lord.
We are going to go by the CPC.
Yes, my lord.
Why?
Because CPC is applicable, my lord.
To me?
Yes.
Land grabbing.
Section 10, my lord.
Yeah. What does it say?
7 otherwise provided in this act, special tribunal shall, in the trial of the case relating to any alleged act of land grabbing or with respect of ownership and title to or lawful possession of the land grabber, whether before or after the commencement of this act, which involves civil liability, follow the civil procedure prescribed in the Code of Civil Procedure.
What does 9 say?
7 expressly provided in this act provision of the Civil Procedure Code and so far as they are not inconsistent with the provisions of this act, shall apply to the proceeding before the special tribunal mutus mutandi, and for the purpose of provision of the state enactment, special tribunal shall be deemed to be a civil court.
They have filed written statement
Yes, my lord, they have filed.
and they have raised 2 preliminary issues
Yes, my lord.
on the question of
On the question of my lord, maintainability as well as my lord, res judicata.
what is this maintainability under section 34 comes into the play.
My lord, this preliminary issue number 1 that doesn't exist.
Why?
Because, my lord, they have said that this proceeding is barred under section 154 of Land Revenue Act.
Why?
Because they have claimed that they obtained the land by way of a perfect partition case.
Then
And 154 bars civil court to give perfect partition.
no, what about section 34?
Section 34, that is my lord, declaration, my lord, of a specific impact.
That I basically I also know. How does section 34 come into the play?
No, doesn't play. That is my question.
Okay, now come to the other one, the second.
Second,
What is the principles of res judicata?
res judicata.
There has been already a decision.
Decision, but that decision relating to which land, that was not decided. And there, one of the party was somebody else.
What?
They
You
have-
you were there or not in that proceedings? Earlier proceedings?
No, my lord.
You were not a party to the earlier proceedings.
Oh, sorry. My predecessor was party.
Huh?
My predecessor was party.
Then
But in that case, plaintiff was different from me. Not this respondent.
what was decided there?
That he has right title interest.
that person,
Yes, madam.
and you don't have in respect to the
Actually,
same
they
land.
have purchased from my predecessor.
So your predecessor did not have right title and interest.
In that.
Then res judicata rightly applied.
We don't, so far as these defendants are concerned, how we don't,
Why? Go and file a suit.
we don't,
Go and file a suit. File a suit.
suits are there, we don't. No,
You see, this is a remedy.
we don't.
First of all, when it is a purely a civil dispute, you can't bring in the Land Grabbing Act. Land grabbing is when there is an allegation that this person concerned is grabbing my land. And when there are evidence to that effect which constitutes you to be a land grabber, very well, action can be taken. Now, whether this will be a 8-2 or not, whether there is a res judicata or not, is for the trial court to decide. Suit.
Special tribunal can decide it.
Why? Special tribunal will only look into if there is a question of land grabbing.
Yes, that day he will decide then why he is going to this res judicata appointment.
When it has already been decided by the civil court that you are predecessor from whom you have purchased did not have title. See,
That land has to be same without. In that case, the court has to come to the finding that land has to be same because my predecessor had 12 acres of land, and I have not pleaded that all these 12 acres have been
12 lessers.
Milord.
Your predecessor, you purchased how much from your predecessor?
No, I have not purchased. My predecessor has purchased 12 acres of land.
12 lessers of land.
Yes.
Yes, then?
Then out of that, a portion has been Milord grabbed by them.
Huh?
Out of that land below 12 acres, a portion of land has been grabbed by the defendant.
You,
Defendant.
the defendant.
Yes.
Then
Then the other person has
have grabbed from your predecessor or from you.
actually after death of my predecessor.
Huh?
After death of my predecessor.
After death of the predecessor, they grabbed.
Yeah.
Then, but you have title over the land? If your predecessor did not have, did you have a title over the land?
That was in respect of 6 acres of land only.
Is the case filed only in respect of these 12 lessers, which was a part of the earlier suit?
That cannot be said, Milord, right now.
Why?
Whether it is part of, because 12 acres. Out of 12 acres, 6 acres, he has got right title in that.
How? Earlier suit said so.
Yes, in that suit, Milord.
Let us see the earlier suit.
That document is not.
So we dismiss it without showing
No,
us.
I shall police it, Milord.
No. We
I shall
dismiss
police
it.
it.
Right off. This is not a matter for that. We
Milord,
dismiss it.
that
On
subject
that
matter-
ground. On that ground itself we dismiss.
Milord, when the land is a different one, then Milord, that is to be decided.
No. File civil suit. This would not bar you from filing a civil suit. You can't employ this Land Grabbing Act for that. There's a basis. Land grabbing, you has to be a land grabber. When a civil court has already decided that aspect of the matter,
Only
tell me, that judgment which has been passed by the civil court,
Yeah.
has it been assailed anyway?
assailed, but failed.
Then, now can this court sit over the judgment?
Milord, that was in respect of 6 letter, that is what.
6 lessers, 7 lessers,
Well,
you have not brought on record that, as I have to believe now. Yes, Mr. Biswal.
Your lordship has rightly pointed out, and in
Yes.
fact, this is an offshoot of an earlier proceeding. Your lordship had the occasion to dismiss his case
So earlier, has the court imposed cost or not?
in earlier case, my lord.
No, here.
No, my lord.
Oh no, we imposed. Don't worry.
But this Lal Babu Shah is
Oh.
playing, my lord, that case, my
Oh,
lord.
same case.
Yes, my lord. The
Oh,
boundary.
you have gone to every extent. This is a land grabbing now.
No, Milord, the party is different. Lal Babu and now this is Goriwala,
No.
Milord.
The lordship will find the title.
Recently also I dismissed some
Yes,
case.
that is in respect of Ram Babu, Milord.
Huh?
Second
Lal
case, your
Babu.
lordship.
This is
dismissed
also
because-
Lal Babu.
Lal
No, my
Babu.
lord.
This is also Lal Babu. Shah.
This
This
going
is also
on.
Lal Babu.
And here the Lal Babu Shah is playing the game, my lord. And he is only sitting in the land, my lord, handing over the
These are
position to
matter
Lal
of
Babu Shah.
These are matter of evidence. my
Yeah.
lord.
That is that compromise.
Compromise, my lord. And it is written in my written
And
statement.
this time, Mr. Sahu, this time the cost will be imposed upon you. Upon you, as Sahu.
My lord, parties are different.
No. Party is same.
Plot of land is same, my lord.
Lot of
dispute is
land is saying there is a compromise. That day I passed an order also,
Yes,
some
15,000
compromise.
My
bill.
lord, that is
Huh?
regarding wall, boundary wall, my lord. That is regarding
Boundary
boundary
wall.
wall.
That
Set
a
of,
compromise decree.
set of regarding, yes.
19, you have taken
Yes,
another how much? 19 years to file a 151.
12 years.
No. 12 years from the date of execution. From the date of the compromise decree, it is 19 years.
Yes.
Yes, I have recorded there.
Setback, regarding setback, 3 feet setback.
3
That is a
feet
different
setback.
aspect.
But
No.
here also the allegation is setback.
Huh?
Here also in the complaint petition filed before the special judge, the setback.
No reason for interfering. Fine. Now this Srimati Gori Gwala,
Yes.
does she have a right over the land?
As per this, my lord, she has a right.
Show me. Show me here document of title. Show me. You want this court to be now, this court is acting as an appellate court. Under 227. Appellate court. So show me her title.
The Jamabandi is there.
Show me. Not Jamabandi. Jamabandi is not a document of title.
That I have to take inspection party.
We dismiss it right now. Is there any stay?
Yes.
No,
No,
no stay.
there is no stay because the
Because my.
No.
his
You have not initiated a proceeding
yes,
there.
execution proceeding there.
No, that
No,
is
no,
different.
no. When a false case is being filed under the Land Grabbing Act, you have not filed the case.
No,
File the case against him.
there we did not file.
I will put this, admit it, put it for hearing in 2034. In the meantime, you file that case and against them, and I will say that that shall not preclude you from proceeding with them. Against false cases, there is a there's a provision out here. Somebody filing a false case. Where is the provision? Yes. There is a one provision which categorically says that a false case being filed, then you can very well take action against him. And array Mr. Sahu also as a party. Same. Lal Babu sir.
Yes, same, my lord. He is the person who is playing the entire game, my lord. And there are six
there-
cases pending before this honorable court, my lord. Two cases your lordship has dismissed.
Hmm.
Another 3 cases are coming up.
So bring those also. And he's the counsel.
Yes.
And he's giving all ideas for everyone.
I can't comment on that.
Lekho. Dismissed with cost upon the council 50% and 50 upon the what?
Hello?
Go file suit if you want. Nothing to do with it.
Yes.
Withdraw it.
Yes, we do.
Mr. S. Sahu, the learned counsel appearing on behalf of the petitioner, submits that taking into account that the order, taking into account the order dated 15/7/2022 in land grabbing case number 6/2019, the petitioner herein shall not like to further proceed with the instant proceedings. He, however, submits that the withdrawal of the instant proceedings, or for that matter, the dismissal of the land grabbing case number 6/2019 should not preclude the petitioner to avail remedies under the Code of Civil Procedure, if so otherwise permissible under law. Taking into account the above, this court dismisses the instant application on withdrawal. It, however, made clear that the order dated 15/7/2022 passed in land grabbing case number 6/2019, as well as the instant withdrawal by the petitioner shall not preclude the petitioner to avail such other remedies available under law, if so envisaged.
Much obliged.
Lal Babu Shah has become famous. Huh? Yeah. Yes, what is this CRPIO again?
My lord, I pray for a commission
Huh?
that was rejected, and against that I come. Appointment of commissioner. Page 43 is the impugn order.
Appointment of commission for what?
Commission for determining the actual position of the land.
Then what happened?
That has been rejected, my lord.
Why?
Why they say that we try to fill up the lacuna. That is the only line. Page 43 all of the time. When I am the plaintiff, my lord, when you see, my lord,
What is your case?
My case is that, my lord, that my land is occupied by the ONGC, my lord, illegally, and they have not paid any compensation to me. Now they are increasing, my lord, by dealing side, and they day by day they increase it, my lord. In 2017, there is a report from the, my lord.
No, understood. Your case is they have occupied your land without paying you compensation.
My lord.
What is the stand of the
They
ONGC?
says that, my lord, not only that, my lord, day by day they increase, my lord. They dealing side they increase, my lord.
No.
That is the.
But with that increase, are they interfering into your land further?
Yes, yes. That is-
Have you amended your plaint?
No, that is, my lord, I have reflected in my plain, my lord.
So they are increasing.
Yes, that is, my lord, and there
Now
is,
let us see what is your claim in your plaint.
my lord. My plaint is page 19, my lord.
Here you have mentioned the suit land, they are in possession of the
Yes.
suit land.
Yes, my lord.
That is 7 bighas 3 lots.
My lord.
Out of 9 bighas so and so.
My lord, yes, they said in the WS, they said that no, their dealing side is not there. That is their claim in their WS, my lord. And in fact, my lord, deputy commissioner, my lord, there is a party, if they has a WS, and they clearly stated that yes, that land is, my lord, under their occupation.
So very well, why do you need the commission?
Because they have denied it, my lord.
So what? When the revenue authority has carried, he is the highest revenue authority has stated.
That, my lord, your lordship kindly see that para 4 of the, my lord, WS filed by the, that's 105.
Page
36,
30.
36.
Then with this, why do you need why you
No, that's
Then-
since they have denied, my lord. See, they denied the point.
so what? Let them deny. This is by the highest revenue
Yes,
authority.
my lord,
Then
that's correct.
why do you require this? This is one of the fantastic proof of
No, but
evidence.
yeah, but they are
You call him.
my lord.
You call that person, the circle officer, and show him.
Why I'm committing, my lord, your lordship kindly see, in there is an inspection in 2017. In the local inspection, my lord, after that I filed this suit, my lord. Their inspection, my lord, they did not, my lord, participate. They did not participate. Now they denied.
Let
That
them
is the-
deny. It is for them to go for that. You are helping them. Why you are helping them?
My lord. So no, since it was rejected on the ground, your lordship kindly see. If that is enough, then, my lord. there
No,
is
no, are you not helping them now? You see, you have a survey report in your favor.
My lord.
Are you not trying to intermeddle with that survey report which is in your favor?
Already there.
Yeah.
And in fact, that is by virtue of their WS, my lord.
Absolutely. This pleading is a proof for that.
Then your lordship finding that, your lordship. Good.
It is they should have asked for that they have it because this survey report is wrong. You have a document for
there is a
that. You are
finding
going to prove that survey report.
Since there is a finding under, my lord, that in order, that they try to find fill up the lacuna. That's why I'm, my lord.
They are saying filling up for the lacuna.
No, that is the finding of the impin order. The order is reflected it, my lord.
Where?
Page 43, my lord, second
No,
paragraph.
no, that is their submission.
No. Oh, yes.
Yes.
That
Yes,
is,
our submission.
that is yes.
Quote, the above petition speaks for the defendant is presently in itself in contrary to that plan have made a prayer. That is why the court has said you are making a prayer against yourself.
So that, my lord, if your lordship, my lord, observing that, your lordship can close it.
This is an application under Article 227 of the Constitution challenging the order dated 30/10/2023 passed in Mizze case number 48 of 2023 arising out of title suit number 26 of 2017. By the said order, the learned trial court, that is the court of the learned civil judge, senior division Sibsagar had rejected the application filed by the petitioner. Seeking appointment of a commission as regards the actual possession of the suit land. During the course of hearing, the learned counsel senior counsel appearing on behalf of the petitioner drew the attention of this court to the written statement filed by the deputy commissioner, Sipsagar, who was a defendant in the said suit. Deputy commissioner, na?
Defendant number 5.
No, just circle officer, sorry. Yes, sir.
Filed by the
Circle.
circle officer, not filed by the circle officer, that is the defendant number 5. Wherein it was categorically admitted at paragraph number 4, categorically admitted by at paragraph number 4 of the written statement that the defendant number 1 was in possession of 7 bighas, 0 kata, 3 lectures of land as per the measurement made on 21/2/2017. And that particular plot of land belonged to the plaintiffs as they were the pata holders. The learned counsel submitted that taking into account this categorical admission of the revenue authority, the said application under order 26 for appointment of a commission ought not to have been filed by the plaintiff in the suit. He submits that, be that as it may, the observations made in the said order dated 30/10/2023 should not prejudice the plaintiff, the trial court, while deciding the said suit. Considering the above, and this court have duly heard the learned counsel appearing on Mr. B.K. Das appearing on behalf of the ONGC.
Yes, my lord. 1, 2, 3.
1, 2, and 3. This court, having perused the written statement which have been filed by the defendant number 5, which is a revenue authority, is also of the opinion that the learned trial court was justified in rejecting the said application. Under such circumstances, this court is not inclined to interfere with the order dated 30/10/2023 passed by the learned trial court. It is further observed that the rejection of the application filed by the petitioner, oblique the plaintiffs in the suit, should not prejudice the plaintiff, oblique the petitioner, during the adjudication of the trial.
Suit was stayed, my lord, earlier, my lord, that may be vacant.
This order you would have got on 4/1/2024 only when you moved. This court further takes note of that by an order dated 4/1/2024, the title suit number 26/2017, which was pending before the court of the learned civil judge, senior division, Sipsagar, was stayed, is hereby vacated, and as the parties are duly represented, they are directed to appear before the learned trial court on 25/2024 for further proceedings.
Obliged.
Oh, FAO,
Yeah.
tell me, what are you challenging?
In this case, not if, appellant, they raised the order that, located with fine at page 91.
There's an injunction order.
Yes.
Okay.
Order 39/2. And that order, my submission is that the pleaded case of the petitioner, pleaded case of the plaintiff is that he was come to an agreement with defendant number 20. And thereafter,
Suit for? specific performance.
special performance.
Okay, then
And thereafter, what has happened, that he did not pay the full amount.
Hmm.
As per the WS fund by the department to, advance money they would not give, and they, after 2.5 years of the execution of the initial agreement of sale,
you are the defendant plaintiff. You are the
I am the defendant number 3,
defendant number
defendant 4 of the suit.
4 of
And
the suit.
the suit was sold to us. By registered sale date with due process of law.
No, no.
And
The defendant number 1, 2, and 3 has entered into an agreement with the plaintiff.
yes,
Thereupon, the defendant number 1, 2, and 3 sold the land to you,
yes,
and you are therefore before this court challenging that order.
no. I am before the court, the person, I am the person who purchased. After
Understood. You are now here who is the subsequent purchaser.
Yes.
And as such, the injunction order is affecting your rights.
Yes.
That's
Yes,
your submission.
Yes,
Because of there is a restraint.
Yes.
We have to issue notice. You have any urgency? No.
at this stage, yes, notice maybe go at this stage, because everybody there matter to be proceed at
No,
this.
I am only asking you, do you have an urgency in the matter?
Yeah, and then she is only that fact that
Otherwise, the matter will go for another 7 years.
yes, that is.
Do you have an urgency in the matter?
Yes, because of the, I could not, even after taking possession, I could not do anything but into that.
So you will take justice service?
Yeah.
Because they are in Guwahati.
Yeah.
Or Rongia. Is in Rongia, na? Plaintiff.
We'll try to get it.
Okay.
Wrong, yeah. Registered court as well as justice service.
That is okay. Because you have an urgency for disposal
yes,
of this
yes.
appeal. Na? That is what I am asking you. Okay. Appeal is admitted. Call for the record. Also, this is an appeal under section 104, read with order 43, rule 1R. Directed against the judgment and order dated. The order dated 29/9/2023, passed by the learned court of the civil judge, number 3, Kamrup Metro at Guwahati, in Mizze case number 15/2021, arising out of title suit number 10/2021, whereby the learned trial court restrained the appellant herein, along with the defendant number 1, 2, and 3, from alienating, developing, encumbering, and or charging the suit land, and or from changing the nature and character of the suit land. The appeal is admitted. Mr. P.P. Borua, the learned counsel appearing on behalf of the appellant, submits that all the materials which was before the learned trial court for adjudication of the injunction proceedings are presently on record. Taking into account the above, this court is not inclined to call for the records. Issue notice to the respondent number 1. To the respondents, number 1 to 4. By steps be taken by way of making it returnable by 3rd of June 2024. Steps be taken by way of registered as well as usual within 3 days. The petitioner, the appellant, is further directed to take steps by way of is also directed to take steps by way of dusty routed through the registry of this court upon the respondent number 1 and file an affidavit of service on or before the next date. এই আইখনত লিখিব এই ওপৰখিনি কিছু নোটিছ সেইখিনি খালি নোটিছ কিছু নোটিছ returnable on 3rd of June 2005. Steps by way of registered post and upon the respondent number 1 to 4 and dusty service as regards respondent number 1. That I is for order 41 rule 5. What is this?
In this matter, my lord, the sole respondent with the plaintiff, my lord, he died on 11/3/2024. So we need some time to file appropriate petitions. My lord.
What?
The sole respondent.
You are the respondent. You are the appellant.
Appellant.
No, you are the plaintiff.
No, the respondent is the plaintiff. He died on 11/3/2024.
Then
So we
11,
3/2024.
the sole appellant.
Respondent, sole respondent. Nihar Kanti Kotal.
Okay. He died.
Died.
Then what do you have?
Well, I need some time to file appropriate petitions for substitution.
Have you filed it in the trial court?
In the trial court, they have filed
Who have filed?
the legal errors of the plaintiff.
Oh, he is the plaintiff.
Yes.
Okay. Mr. So-and-so, the learned counsel appearing on behalf, as does appearing on behalf of the appellant, submits that the sole respondent had expired on
11/3/2024.
11/3/2024, and as such, he seeks some accommodation to take appropriate steps.
For the
Leaves the matter after
first week of May.
3 months, 2 months. 3 months is there for abatement.
Or 11th ballot, already ballot, around 40 days.
Oh.
From the date of death.
11/3, how much today? 40 days. Another 50 days is left.
Yes.
So, list the matter after 6 weeks. So, in the meantime, the petitioner, the appellant would be at liberty to file appropriate application. Appropriate application. So, it is further mentioned that if such application is filed, the appellant would be at liberty to mention the matter for being taken up.
Highly obliged.
Yes, Mr. Mary, last time you sought for time.
No, my.
When a matter came up,
Not reached, my lord.
not me.
It-
Yes, tell me.
Matter election, my lord, is, my lord, suit was, the gentleman who then declares for the ex parte, my lord.
Huh?
Ex parte order was passed in suit, my lord, money suit, my lord.
Then,
My lord, is, we came to know, we file, money appeal with, concerning delay, my lord. Delay petition was dismissed, my lord. Yes, my lord.
wait.
And accordingly, appeal dismissed, my lord. Judgment, my lord, is from page 10, my lord. Is regarding my discrepancy in the passport, my lord, his number, my lord. The plaintiff was uploaded, my lord, there from in Kolkata airport, my lord. Journey was in Singapore. Due to
no, why are you, what is the substantial question of law?
yes, my lord. My substantial question of my law, my lord. Page 8, my lord. Page 8, my lord. It was, my lord, expert order was there is no information.
That first is not a substantial question of law. 2 is not a substantial question of law.
And
3 is not a substantial question of law. 4 is not a substantial question. So, appeal should be dismissed. Come up with better. These are not, this is not a court of appeal.
Yes.
It's a court of second appeal. It has to be on a substantial question of law. It is not substantial. Pay me properly.
Yes.
The learned Mr. S.K. Medi, the learned counsel appearing on behalf of the appellant, submits that the substantial questions of law which have been formulated have been proposed do not seem to be in order, and as such, he seeks an accommodation of 2 weeks, 3 weeks, 2 weeks time for submitting a fresh draft of the substantial questions of law. This is the matter of 2 weeks. What is there?
Concurrent finding.
Then, on that ground
Evidence.
only we dismiss it. What do you say? Concurrent finding. I still remember when we started our practice, we had Justice Jain Sharma. By the time we reached here, and he sees out here and sees that it's a concurrent finding, it's dismissed. Yes.
No, this is not an inviolable position of law. No.
Huh?
Concurrent finding is to be.
Yes. Then tell me.
Now, appellants are the plaintiffs. It was for right title interest in respect of 5 cutters of land on the basis of their sale deed and recovery of possession, which has been incorporated by your amendment. Now, before I go to into judgment lordship, plain it starts from 12 first.
You are the plaintiff.
Plaintiff.
Your suit has been dismissed. What is your suit for?
Suit for right title interest
On what basis?
of sale deed or sale deed of 1972 as it was mutation.
Huh.
Decree for recovery of possession and cancellation of sale deed.
Page 23 is your prayer in the suit.
Type copy is page 15. Page 20.
A decree declaring the absolute ownership and title of interest of the plaintiffs over the Schedule 1 land, decree for recovery of possession by evicting the defendant, a decree declaring the defendant did not have the title and interest, did not require any right title and interest, whether by the what? What is the relief number D?
For decree for D is page 24, Lordship.
Huh?
Cancellation.
What is D?
After amendment, it becomes D is declaring that the defendant number 1 did not acquire right title interest and or possession over the suit land by deed as described in the Schedule 2 below. By the deed sale deed. It is
What sale deed?
defendant number 1 purchased land from defendant number 2.
So you have not challenged the deed of sale.
We have challenged.
Where?
Next page, Lordship. For cancellation of taking.
Okay. So without asking for cancellation, you have asked first for he did not acquire title and then cancellation. Yeah. Then
Recovery of possession is also
so
there.
you have a recovery of possession. Okay, then what happened? So the issue must be whether you have right title interest, whether the truth.
Yes.
Trial court judgment.
3 and 4. Issue number 3 and
Page 39. What are the issues framed?
3 and 4 at page 46. Issues is page 44.
3. Whether the plaintiff has absolute right title interest over the Schedule 1 land, whether the deed described in Schedule 2 is malified. Okay. And how is number 3 and 4 decided?
Page 46.
Before discussion on the issue of the imminent council second evidence.
From page 48, we can right title and interest.
Up to page 47 is in our.
What is exhibit Z?
Exhibit G is exhibit 2. Exhibit 2 is a Jamabandi of this patta number 24, which is exhibited by us. And they have exhibited exhibit G.
Ah.
Same document.
Then
They are saying that their predecessor name was not Prakop.
whose
But-
name?
Their predecessor, from whom we have purchased.
And merely on the basis that you said that there is 8 bighas of land, the court totally negative your sale deed.
Yes, we have purchased by the sell date 4 biga 13 kata.
The
4 biga-
question is whether that your predecessor or the vendor had the right over 4
It's
bighas.
their predecessor. Our vendor is their predecessor. It is second
Therefore,
sale.
yes.
Their sales, and they have admitted lordship. In
No,
the
no, merely because you said,
I have not.
No, no.
In this different patta.
no,
Patta number
in the
20.
cross,
Oh yes.
you
yes,
say the dark number 38 and Dag number 44 and 45 contains 8 bighas
Yes.
in your cross.
Yes.
The court says, if that be so, how they say that they have purchased the entire in the deed of sale when it is has only 4 bighas?
Yes.
Isn't that the reason?
Yes, it is the reason.
Or am I finding something else?
No,
Kindly
it
come
is
to
the
page
reason, and
51. Let me
presumption-
come back.
Yellow.
Let me come back. Kindly come to page 51, that paragraph.
Both the court held that the section presumption of section 90 will not help the plaintiff. And this in 8 bighas is in respect of 2 patta. And 2 patta is only 1 patta.
Now let's see. What are the substantial question of law?
Page 8, Lordship.
I have seen it. Which one?
2 will cover the question raised by the Lordship also.
Your suit was for
Right title interest, recovery of position
of 4 bighas.
of 5
Of
five-
4
five-
katha,
five
8 letters.
5 cutters.
Huh?
In which stood 5 cutters?
Page 16.
Page 16, 5 cutters.
Where?
Land measuring 4 cut 8 chotaks, the third
And
line
8
below,
8 chatak.
and in Dag number 45, land measuring 8 chotaks, totaling 5 cutters.
How much chataks is 1 katha?
16 chotaks, 1 cut. And in their return statement, they have stated that we can claim at best in this patta number 24, 17 kata. Is their admission.
Now, the instant appeal under section 100 of the Code of Civil Procedure 1908, it directed against the judgment and decree dated 4/2/2022, passed by the learned civil judge number 1 Kachar at Silchar, whereby the title appeal number 19/2018 was dismissed, thereby confirming the judgment and decree dated 29/9/2018, passed by the learned Munsif Lokhipur Kachar, whereby the title suit number 23/2014 was dismissed. The instant second appeal is admitted by formulating the following substantial question of law in terms with section 100(4) of the code. Whether the courts below were justified in holding, in arriving at the opinion that the deed of sale bearing deed number is how much?
Deed number is lost.
1057, dated 19/4/1972, was a vague document by relying on the basis, relying on the evidence of PW2 without taking into account the documentary evidence which were already on record. I think that is suffice. We have the perversity.
This is purpose misreading of these documents. There is purpose. It will cover both exhibit 3 and this exhibit 2 will be misread by the court.
What is exhibit 2 and?
Exhibit 2 is the Jamabandi and exhibit 3 is the Sale deed. It's 1972.
And exhibit 2, did it show how much land it was there?
Area is not.
Now, Jamamandi, the land will 100% be shown,
No. How much purchase it is not.
not necessary.
It is there. It is there.
It will show how much? Four kathas.
No, lordship, it is total 2 biga something. 2 biga something. Or
Huh?
3 biga. 3 biga. There in the plain picture. 3 biga. In 2 ducts. 3 biga 6 kathas 12.
More particular, line to ki likhle last week, ne? Well, was a vague document. Vague. That is more specifically exhibit 2. Number 2, whether the judgment and decree passed by the learned trial court, by the courts below, where suffers from perversity. I think that will do. One will do. I call it issue notice, making it returnable by 6 weeks. Steps be taken by way of registered as well as usual upon all the respondents. Let's call for the LCI. What is this IA for?
IA is for delay.
Oh, we have condoned. Somebody appeared on the last occasion.
No, was appeared in this case. There is another case in that case.
22 days, no?
Yeah.
Delay was 22 days.
22 days.
Much okay.
Item 11.
May I please your,
Yes,
my
Mr.
lord, though it is against the concurrent finding of fact and law.
Hmm.
But my lord, the learned trial court, I failed to appreciate my lord, as well as the first appellate court, regarding the provisions of order 32, rule 1 to 14, and thereafter my lord 15. Because the plaintiff himself has pleaded that my lord, one of his brother was, suffering from schizophrenia, and my lord, he had executed the sale deed in the year 2006.
What was the suit for, Mr. Sutar?
Suit was, my lord, for declaration of right title interest and cancellation of the 2 sale deed.
Declaration of the plaintiff number 1 is the owner of the suit land by inheritance and on amicable partition.
Yes, partition they admit, my lord.
That the second schedule land, that the second schedule mentioned documents be declared as illegal collusive for permanent perpetual injunction. So it is a suit for declaration as well as
Yes, my lord.
Now you claim your right on what basis?
On the basis of purchase from the brother to whom plaintiff number 2 declares or desires that he is suffering from schizophrenia.
Wait, you purchased the
I purchased the land from Harunur Rahman, who is the plaintiff number 1, my lord.
Khaliur Rahman. You purchased the land from him.
Harunur Rahman.
Plaintiff number 2?
Plaintiff.
Khalilul.
My lord, plaintiff number 2 is the brother of Harunur, and he filed the suit.
Khalilur filed the suit.
No, 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 no. You
lord-
purchased the land from
I purchased the land from Harunur Rahman.
where? He's not a party.
He is not a party, my lord.
Okay. And then
And the plaintiff number 2 claims that the brother amongst whom the division was there sometimes in the year 1994 by way of registered, the partition deed, my lord. After that, Harunur Rahman started suffering from schizophrenia.
Hmm.
But the doctor says that no, only the day on which the doctor has examined my lord, before 2 years, he is suffering from 40% disability.
Hmm.
But my deed was of the year 2001 and another was 2006. The suit is filed in the year 2013, my
2011.
2011, 2011.
Hmm.
And DW4, my lord, who is the PW4, who is the doctor, he says that the day on which I examined him, only from 2 years before, he was suffering 40% disability.
Okay. Now let's see how what is the defense of the defendants?
My lord, my defense is that the person who has sold the property.
You are the defendant.
I am defendant.
Okay. Then okay. Now the plaintiff number 1, Harunur Rahman, is suffering from some illness.
Yes,
And the plaintiff number 2 filed the suit
yes.
on behalf of the plaintiff number 1 and himself.
Himself, yes.
And what right does the plaintiff number 2 has?
My lord, he says that I was taking care when he was suffering from schizophrenia. That's what is written in the plea.
How do you file the suit?
I did not file the suit. They filed. I am the defendant.
Okay. Uh-huh.
I am the purchaser. I am the purchaser.
Because
of
they cannot file the suit like that unless I think you have the Medical Healthcare Act.
Exactly, my lord. Medical Healthcare Act. Moreover, my lord.
Or you have to take a permission from earlier it was the 87.
Yes.
Medical Healthcare Act 87 was there.
Yes.
Now with Person with Disabilities Act in 2016 the thing is become different. But earlier I think the 87 Act was holding the field. Then you had to take the permission from the district judge,
Yes. From the court.
isn't it?
My
And now the suit has been decreed
the suit is decreed.
and the appeal has been
It
dismissed.
also decreed in their favor.
Okay, what are the substantial questions?
My
of
lord,
law?
at page number 11A and at page number 12E.
E.
E. Apart from that, which your lordship is going to grant. Because the first appellate court also, my lord, did not formulate any points for determination. Only the 6 number of issues which were taken by the trial court, that has been answered by.
And how section 80? What is section 80 for?
80 was, my lord, that if your lordship pleases to see the plaint, my lord, they say that we will take steps for serving the notice upon the defendant number 7, 8, and 9.
7 is not here. Page 17.
Yes.
There is no 7.
Can you see the plaint, my lord? It is-
They are struck off. 7, 8, and 9.
My lord, 7 is state of the sum. Notice to be served on government pleader, Karimganj, PO, so and so, so and so. And 8 is the sub.
And why is the state of Assam being made a party? Unnecessarily. So not necessary. That is not an issue. But did you raise the issue as regards the Lunacy Act?
My lord, in para
That-
number 8 of my written statement,
Para?
para 8 of my written statement, my lord, my WS is from 29 to 33. It is the type copy. Original copy 34 to 40, my lord.
No, where did you raise?
My lord, in para number 8.
8 doesn't say anything. should have been the main, yeah. Kindly come to,
My lord, in para 8, lastly, I am saying that the plaintiff number 1 is not a patient of schizophrenia.
where?
My lord, para number 8, last line. mein. And paragraph number 2 also, my lord, of the written statement. Kindly, my lord, have a look at the typed copy.
Let's see the issues which were framed.
Yeah, issues your lordship will be pleased to find at page number 28 and 23.
42 page.
Page 28, my lord. This issues are 53 and 42.
No, page 42.
42, yes, my lord. That is also containing.
Where is the issue? No issue.
No issue on that.
Then what do you, why didn't you raise that? Did you take it as a ground of appeal?
My lord, that in the memo of appeal I have taken.
Let's see the additional issues. Where are the additional issues?
Only one additional
Whether the
issue, my
suit
lord.
is maintainable in the
One
present form. That is it.
Whether the suit is maintained.
Number 6. What is number 6? How it has been discussed?
Page 57.
Mhm. Suit was filed in 2011.
Yes, my lord.
At that point of time, I think the 87 Act would apply. I will take it up again on Friday. You come up with that particular act and look into that. Because why you have raised that issue, so the court should have looked into in terms of the mental health care rather than go into this 1993 All England or Allahabad judgment.
That is 1993, my lord. Page 111, I mean, page
247.
447, yes. That has been looked into. But in that case, my lord, I have gone through that judgment, my lord. The application was filed. The London Trial Court did not pass any speaking order on that. But here, my lord, there is no order at all. No application at all. There was an application.
Because there is a requirement of filing an
Yes, my lord.
application.
Yes, application is
Yes,
required.
there is a requirement of filing an application. And how does the first appellate court take note of that?
My lord, the first appellate court's judgment starts from 101 and issue number. The first appellate court also has only decided the issue, additional issue, my lord, the 130.
Mental health care, 1980. But you say that he is not of unsound mind.
That plea we have taken, yes.
Now, if he is not of unsound mind, the suit should have been filed by him. The suit has been filed by him.
Name is shown, my lord. But yes, only name is shown. Sign is only by one. By Khalilu.
Now, let's see how does the plaintiff where is the entire plain?
Plain, my lord.
No,
as
you have only
we have-
enclosed till
we
the
have-
verification.
Yes, my lord, we have.
Where is the affidavit?
My lord, 16 to 24 is the type copy
Understood. Where is the affidavit?
and 25 to 28, my lord.
Where is the affidavit?
Original copy, my lord.
Where is the affidavit?
No, there is no affidavit, my lord, only verification.
Can't be. How can it be? This is a suit of 2011.
Yes. But
Then-
my lord, whatever was served upon us, my lord, that we have.
It can't be served upon you. What is the requirement? If the plaintiff say, if it is alleged by you that he is of unsound mind, then only an inquiry is required.
The plaintiff himself says, my lord, plaintiff, I mean, Khalilur Rahman himself says, my lord, that the plaintiff number one has been suffering from acute schizophrenia disease since long years. That the plaintiff number one is a bachelor. The plaintiff number one is the member of the joint family of the plaintiff number two. And that plaintiff number two and his family members have been maintaining all the affairs, including the livelihood and other maintenance of the plaintiff number one since long years as a member of their joint family with knowledge of all, including the defendant. Thereafter, in para number 3, my lord,
So how do you bring in order? Where is it said about unsound mind?
he simply says about this schizophrenia, my lord.
That's two. Kindly come to order 32, rule 15.
Well.
Shall so far as may be apply to person adjudged, comma,
My lord.
before or during the pendency of the suit to be of unsound mind, and shall also apply to person who, though not so adjudged, are found by the court on inquiry to be incapable by reason of any infirmity, medical infirmity, of protecting their interest.
When suing or being sued.
Then you see, if a suit is being filed by a person of unsound mind, it has to be then taken off the file. That's order 32, rule 2.
Yeah.
But if the court does not do it in view of the presence of number 3, plaintiff number 2, wouldn't that be amounting to allowing a leave by the court
For that,
in
my
terms
lord,
with without an application?
so
Isn't it that a curable defect?
in my respectful submission before your lordship, it cannot be.
Why?
Because of the reason that when the law demands that there should have been an application, seeking leave to file for and on behalf of the, person of.
No, anyways, when a leave is being sought for,
My lord.
what is the requirement of the court to do? The court has to issue notice to the guardian in the case of a minor.
Yes.
Now, if the father and the mother is not there, or a duly appointed guardian is not there, then to the person with whom the person who is taking care of him,
Care of.
and he says that he is taking care of plaintiff number 2.
He says that he is taken care of,
Yeah.
but since when, my lord? Since when?
He says that he has been taken care of since he is suffering from schizophrenia.
My lord, but the doctor says that he is suffering from schizophrenia only since last 2 years.
So,
Last 2 years means the date on which the doctor examined him. And the deed which was executed, my lord, is of the year 2001 and 2006.
no, we are not concerned with the deed. That is another aspect of the matter.
Well,
We are on the question on the first,
on
on the maintainability of the
insane or sane. My lord.
maintainability of the suit is there or not. Whether he was unsound mind at the time of execution of the deed is another aspect of the matter. That is another substantial question of law which can be very well looked into. That is another. But on the question of maintainability of the suit,
My lord, the law demands that there should have been an application.
now
It
if
may or
it
may
is
not
not
be-
so,
If he, then the suit is not maintainable because he has not followed the procedure prescribed in law. My lord.
but the
According to
court,
my-
but isn't that a curable defect when the board by the courts allowed the proceedings to go on?
Lord, that defect is not cured as of yet. That defect is not cured as of.
No, when the court, I mean, it's only a leave. The court has granted the leave. They are proceeding with it.
No need. My lord, may I take the lordship to that 15?
Just for example,
15 again, my lord.
uh,
15. Though your lordship has pointed out that,
Hmm.
my lord, rule 15.
Hmm.
Rules 1 to 14 except rule 2A
Hmm.
to apply to persons of unsound mind.
Hmm.
Rule 1 to 14 except rule 2A shall, so far as may be, apply to persons adjudged before or during the pendency of the suit, adjudged before or during the pendency of the suit, to be of unsound mind, and shall also apply to persons who, though not so adjudged, are found by the court on inquiry to be incapable by reasons of any mental infirmity or protecting their interest when suing or being sued. So that inquiry has also not been done.
no. Allahabad High Court say the mere absence of a formal order appointing a guardian shall not invalidate. That is what has been held.
True, true.
It doesn't seem to be wrong on that.
But my lord, in that case, in the Allahabad case, my lord, the application was made. Only
It's a
the-
different thing. The ratio, that is on the facts.
Yeah.
But the ratio laid down is that it is a curable defect.
My lord, in my respectful submission before your lordship, actually the suit is not maintainable.
Hmm.
Because of the reasons that the laws which are framed and made are not followed. We will desire that your lordship, and my lord, your lordship, that question. This was not accepted by the registry. We do had this original claim where only it ends with the verification man.
Hmm.
Only verification, no affidavit after 2002.
Because there some statement may have been made. Now, how have you filed the suit? The appeal. The appeal is directly against whom?
I have filed them
Against whom?
against the Khalilur Rahman.
Only,
Yes,
not against the brother.
I have shown his name also, my lord. I have shown his name.
How?
And the legal heirs of.
Can you institute a suit against a person with unsound mind or appeal?
My lord, if I can take to the. memo-
Unless you take the leave.
Memo, my lord.
Yes.
Versus legal heirs of Harunur Rahman.
Haruna number is alive.
No, dead.
The plaintiff number 1 is dead.
Dead.
And he had these sons and daughters.
My lord, this Rajia Khan, daughter, and then Saira Khanam, wife of so and so.
What are these wives are different names, why? Or these are daughter?
These are daughters, man.
And who is Saira Khanam?
My lord, Saira Khanam is the daughter of,
There's no mention.
wife of Mujibur Rahman Chaudhary.
He's another person.
Yes, my lord.
He's not a daughter.
No, my lord, this Muhammad Saira Khanam is married to Mujibur Rahman.
But he's not a daughter.
She's the daughter, my lord. Saira is the daughter.
How do you say so? Because in case of Rajia Khan, you have put it as daughter.
Yes.
Hajira Khanun, you have put it as daughter. But Saira Khanam, you have not put it as daughter.
And that is not good, my lord. That name.
Huh? And then the four are all sons. Now, why they were not a party to the suit? Why they did not approach?
My lord.
Why they did not approach at that point of time? At that point of time, why the suit was filed by the brother?
Yes, at that time they did not approach, man.
Then how can they,
No,
what
my
were
lord,
their
at the
age at
time
that
of
point?
Filing of the suit,
Uh.
Harunur Rahman was alive.
Yes, understood.
Yes.
What
but
was his age? 54.
At that time.
Yes, if you see the claim. And the Khalilur Rahman was 72.
72. Harunur was shown to be 54.
So therefore, at that point of time, he had these sons and daughters. Even his wife, if I'm not wrong. Where's his wife?
That
Another daughter.
shall have consulted.
They're all
the court.
daughters. Who are these people? All sons of so and so. And B and C, what are these?
In the memo of appeal, my lord.
At page 4. Who are these? B and C?
He-
Page 4.
Rahimul Nisa. Daughter of late Ahmad Ali. My lord, Ahmad Ali had 3 sons.
Who is Ahmed Ali?
Ahmad Ali is the father of Harunur, Khalilur, and one more person.
Then why you are making them a party?
Because after Harunur's death, my lord, they become, because the daughters can only get, the half of the share.
So the daughters are already there.
If they are there.
But how are these two B and C relevant? And when did Harunur?
Can I take your lordship to page number
No,
69?
wait. Another aspect. So at the time of appeal,
Yes, my lord. Page number 69, my lord. Page number 69. Check 4. They were aided by the late courtman.
now where is number 2? Harunur. Harunur died. And these people were made parties.
Yes.
Then what is wrong? I don't think
So,
this
my
is a
lord,
point of determination, point of substantial question of law. Okay, show me another one. Not a substantial. You'll have a, say, it will amount to passing a, admittedly at the time of filing of the suit, the person concerned was suffering, alive, but he was suffering from schizophrenia.
At that time, according to the plaintiff, number one, plaintiff number two, sorry, madam. According to plaintiff number two,
And the court proceeded with it.
yeah, and but we do not know. We have challenged that part of the matter. Yes.
You challenged it, but you are saying that you were good, had a good thing. Then the evidence was brought in, and the court had the inquiry, and then also the court proceeded. The court could have stopped.
Yes, my lord, his examination was in the year 2009. And the doctor says, DW4 says, my lord, PW4 says that when I examined, at that time he was suffering only from 40% disability,
In 2009.
2009.
So in 2011, it has become more than that.
Yes, my lord, yes, maybe. But my lord, I am not concerned with either 2009 or 2011 when the suit is filed. I am concerned that the property.
2001,
And 2006, my lord.
2006. So therefore, let us go to 2006, that other point, not on the point of limited maintainability.
No. My lord, 2006 also he executed another deed.
Understood. That is a different aspect. I'm not framing a question of law on the question of maintainability of the suit. I will frame some other substantial question of law on some other thing, provided you satisfy this court.
Yes, my lord.
As of now, I'm not satisfied with Order 32. Yes. A Mr. Sattar, I'll give you 1 week's time. These substantial questions of law which are there, these are more like grounds. These are not substantial.
My lord, let it be.
Your basic idea, which you want to say, that you see the evidence of PW3 or whoever it is, the doctor, shows that this person concerned was at that point of time not was suffering for 40% schizophrenia.
That is the doctor.
The trial court or the first appellate court did not consider that aspect as to whether in the year 2006, when the deeds were executed, whether the person concerned was suffering from any disability which could have affected his ability to execute the law. That should have been your substantial question. Bring it out in a proper manner.
Right.
Well,
Third of
Third of me,
my lord.
at the request of the learned counsel appearing on behalf of the appellant, the matter stands adjourned to be listed again on
My lord, kindly make it, my lord. 6, my lord.
6th of May, on which date he shall produce he shall place before this court a fresh set of substantial questions of law to be proposed.
Oblige, your lord.
I think that would be the substantial question of stating out there as to whether the evidence of the doctor being taken into account would have been of such an effect that the person concerned would have been incapable of executing. Whether that aspect was considered. I think that is that may be a substantial.
We'll bring it.
And that would amount to also a perversity.
Yes. Oblige, your lord.
I know 44. say better.
Okay, please, your lordship. Matter will be passed on for the time being, lordship.
Madam, first let us see what she says.
Lordship,
What are you challenging?
Lordship, before your lordship goes into the merit of the case, lordship, actually nothing survives anymore because few days back they have filed one affidavit wherein they have stated that we have my client has gone into another agreement and sold out the two property. I did not have the knowledge, so I clarified it with my party. He did that.
So you withdraw. Okay. The learned counsel appearing on behalf of the, this is an application challenging the order dated 15/12/2022 passed in Ms. case number 06/2019, whereby the learned court of the civil judge Borpeta had rejected the application filed by the petitioner under Order 21, Rule 106, read with Section 47 and 151 of the Code of Civil Procedure 1908. Ms. Idas, na?
Sure.
The learned counsel appearing on behalf of the petitioner submits that the petitioner has no further interest in the said suit property and as such would not like to further press the instant proceedings. Who's taking into account above, the instant proceedings stands dismissed on withdrawal. The interim order dated 18/10/2023 is vacated. Certainly, the execution proceeding shall proceed in accordance. Yes. Oh, Advocate General appearing. What is this matter about?
Lordship, this is a money suit in which they have sought for amendment of a written statement.
Huh?
The defendant has sought amendment of written statement
Huh.
in a suit of a commercial nature, Your Lordship, contractual dues.
Then
So the amendment petition was rejected, and against that they appeared.
they filed, who
The
filed the amendment
defendants.
application
The defendants
of the written statement?
of the written statement.
Why was it rejected?
It was rejected because in the amendment application, what is thought to be amended was not clarified. It was
Oh, is it?
yes, Lord.
Madam, you are the state of Assam. You are appearing in this matter? From Borolal Territorial Council. Earlier, your Advocate General was appearing.
They are standing on.
Mr. D. Saikia, the learned Advocate General, appearing on behalf of the petitioners and assisted by Mr. K.K. Dutta.
They are standing counsel of.
So we dismiss it for default.
I will inform.
Ask them by 2, else I am dismissing it for default.
46 and 47 are
Same. Please?
yes, sir.
Okay. 2 o'clock. What is this?
Lord, I was ordered to take Dosti service, my lord. Dosti service was refused. And affidavit is ready, my lord, to be filed. But what happened, my lord, Mr. Thak?
What is this IA for? I for what?
my lord,
803, 8 days.
limitation, my
We do one thing. We dismiss that matter ends out there. Why should we go into all other? Where's the I got it. 880. Why? Judgment last date for filing the connected RSA was demand. So there is a delay of demand. Yes, we dismissed it. No ground.
lord,
This can't be a ground. Everybody will come up. Then why don't approach the legally?
let this
Do whatever maybe. You can't do this.
service be complete, ma'am. Service be complete. ma'am.
Not necessary.
Your
Why
lordship,
unnecessary these type of
your
matters?
lordship given me option to take
Huh?
those service on the.
Not necessary. Type of matters. One person you could not serve it. Hello. Hello. This is an application for under Section 5 of the Limitation Act 1963 for condoning the delay of 808 days in filing the regular second appeal against the judgment and decree dated 27/11/2014 passed by the learned Civil Judge Dhubri entitled Appeal Number 48/2011.
830, ma'am.
808 days. You say.
In my copy, my lord,
From your application, it is 880. Let us see here. 808 days.
is it, my lord, IA number 4001?
Okay. It appears from the records that pursuant to the filing of the instant application, this court had issued notice upon the sole respondent on 6/12/2017. The record reveals that the service could not be completed upon the respondent. This court further takes note of the fact that that directions were also given to effect service upon the respondent by way of the mode. However, then also, neither service have been effected by way of the mode. And on the other hand, it is seen that on various occasions, time have been sought for submitting the affidavit of service. This would have also, taking into account that the service had not been complete, this would have perused the grounds on which the delay have been explained.
My lord, it is not a concurrent finding. My lord, your lordship will consider that this
A perusal of the application reveals that a delay in filing the application occurred on the ground that the applicants did not have the financial resources to bear the cost of the appeal and to pay the fees of the advocate.
my lord, my para 3(5) may be considered.
You are the defendant. You are the plaintiff or the defendant. You are the plaintiff.
The plaintiff.
Plaintiff.
It was decreed, my lord. Earlier it was decreed, thereafter it was. It was this. Page 44. my lord. But if necessary, some cost may be imposed. my lord. That is also my lord. If enter appeal is it. For limited to ground. Page 9 of the RSC may be looked at. Around 29. Suit is decreed on contest with cause. It is declared that plaintiffs have right, title, and interest over the land. Entitled to degree of hardship. The affidavit is ready, my lord. Only thing is this, my lord, Mr. Shah's brother-in-law died. He's in grief. Brother-in-law of Mr.
Service has been meted out.
My lord, it, whatever, my lord, we approached for justice service, but it is refused. That is why we have to file affidavit. Affidavit is ready.
That has been almost 2 years back this happened.
My lord. My lord, it
Yes.
was order dated.
2 years back.
Order dated.
No, only thing, Mr. Sheikh,
My lord.
if the affidavit is filed, one thing is there, I'll just deduct that portion and then also dismiss it. The finality of that order is not there, dispute.
No,
That only thing is, if you file the affidavit today, then it will be, service has been duly complete, they have not appeared, then I'll dismiss it.
let me complete, my lord. Otherwise, blame will come to us also.
For what?
That,
No,
we
blame has to come to you.
My lord,
This
no,
can't be
we
done.
have not taken care of this.
No, sorry.
My lord, let the affidavit be filed.
No, Mr. Sheikh, nothing. This is, I'm.
My lord, the affidavit is ready, my lord. Only thing is this, my lord, his brother-in-law died.
Let this court now consider as to whether the said grounds which have been assigned can be a sufficient cause within the meaning of Section 5 for condoning the delay.
My para 5 may be looked into it. Of my petition.
The Supreme Court recently, in a judgment in the case of Pathapati Super Reddy, bracket died by LR and others versus Special Deputy Collector LA, reported in 2024 SCC Online, SC 513. After making a copious decay of all the proceedings, well-settled proceedings, had summarized the principles for condoning the delay. Paragraph 26 of the said judgment, being relevant, is quoted herein below. From the perusal of the various subclauses in paragraph number 26 as quoted herein above, the Supreme Court duly observed that the provisions of the Limitation Act have to be construed differently, such as Section 3 has to be construed in a strict sense, whereas Section 5 has to be construed liberally. It was further observed that in order to advance substantial justice, though liberal approach, justice-oriented approach or cause of substantial justice may be kept in mind, but the same cannot be used to defeat the substantial law of limitation contained in Section 3 of the Limitation Act. it was categorically observed that the courts are empowered to exercise discretion to condone the delay if sufficient cause have been explained. But that exercise of the power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors such as where there is inordinate delay, negligence, and want of diligence. This court now, in the backdrop of the above, let this court now take note of the application and the grounds which have been mentioned. From the above, from a perusal of the said applications, it will be seen that the ground so mentioned is on account of poverty of the petitioners. It was beyond the control of them for filing the said appeal within time. This court have also perused a copy of the claim and the documents which have been enclosed with the memo of appeal. Nowhere there is any mention that the plaintiffs, the appellants who are the applicants who are the plaintiffs, were at any point of time facing financial difficulties. In the instant application so filed, there is no mention that as regards any new financial difficulty which has arisen, any new reasons for which any financial difficulty has arisen. Merely by stating that the applicants could not procure the resources, the financial resources to pay to the council, in the opinion of this court, would not constitute a sufficient cause for condoning the delay. Accordingly, this court finds no reason for condoning the delay for which the instant application stands dismissed. Taking into account that the instant application had been dismissed, the accompanying second appeal, being barred by limitation, cannot be entertained. Number one. Yes, Y13 has come. LCR for TA and TS have been received.
Yes.
Service is complete.
I'm appearing for.
Okay. Service being complete and the LCR having been received, list the matter for hearing in its usual course. Yes, what is the CRPIO for? Let's finish it off. Oh, yes, what has happened?
Well, I was unable to file my additional WVET. As per the last order, Lordship has directed me to file a fresh copy of the interim order, which I have already filed.
Then,
My lord, on the last.
what has happened to the other side? Where is the other side? Is it stay?
No, not the state, but the private part. But my lord has inquired whether there is a unsafe court is there in Pilatsipara.
Huh? You wanted to file a?
I have filed an additional affidavit because there was some typing mistake in the impugned order, lordship.
Yes, yes. Copy of the impugned order. Where is that? Page?
Page 20, lordship, may kindly see the additional affidavit,
No, page 27.
27.
Where's your friend to oppose? Where's your friend to oppose you?
But the last occasion he was there.
Then,
They-
chalo, we'll take it up at 2 after that matter. We'll dispose it off. Earlier you were asked to pay 1,000. Now you are going to pay 5,000. Chalo. You get hold of your friend. Why?
It is apparently.
So what?
It's not.
Sorry. I don't grant any adjournments for these type of matters. What is the stage at which you file this application? Who has filed for amendment?
The dependents.
PTC.
Who filed the suit? You wanted to adduce something else. What was the state?
Yes.
The suit was filed by the contractor, you know, the non-payment of contractual dues.
Where's your amendment application?
Is that page 47, the next 9.
So, what you wanted to amend? What do you want to amend?
Some documents are not enacted.
What is these documents are annexed or not? Your petition does not say what you want to incorporate. What type of application is this? Why? I don't grant adjournment in this type of matter.
Can for time being, I just inform it. Just I am going to inform it. Sir.
You inform whoever it is.
My,
I don't grant adjournments in these type of matters.
My lord, just time being,
It's a commercial suit,
no money,
money suit.
I'm informing it, sir.
You inform him. I don't grant adjournments, whoever it is. Yes, Mr. Decker, where are you? Will you get hold of your friend? Yeah, he.
My lord, before taking the matter on merit lordship, I would like to inform that the respondent number 2 has already died, lordship. So my lord, whether it will be awaited or not. At this stage, my lord,
Who died?
respondent number 2. I am for the respondent number 1, 3, and 4. It is informed to me by the other respondents.
You are the plaintiff.
Yes, lord.
Yes.
You have substituted yourself there.
My lord, just my lord, inform me, my lord, before filing Bokalat number that 2 has been died.
This is with respect to filing of written statement only, my lord.
You were the plaintiff, no? Where's the plaintiff?
Plaintiff is not an ex lord.
No, no, thank the plaintiff, because they have filed written statement to the plaintiff. Subsequent to that, they have amended their plaint. To that effect, I wanted to file a subsequent.
Where's the amended plaintiff?
But I have not annexed it.
The plaint which is there is filed for what? The problem arises out here. He will have a lot of problems. There's a stay, na?
Lordship.
Then he
Not
cannot. Huh?
There is
Not
no
stay,
stay
lord.
here.
So did you file an application out there for substitution?
Proceeding is not state law. Yes,
But
lordship,
it's
I'll advise lordship. Now, whether you lordship will take the matter, lordship, in view of my date of the respondent number 2, lord. On merit.
Mr.
M.H.
M.H. Ahmed, appearing on behalf of the respondent numbers 1, 3, and 4, submits that the respondent number 2 expired on.
Well, date is not given. It is,
Then what are you mentioning out there? You
my
don't know
lord,
about it.
just inform me, lordship, he has died, lord.
When?
My lord, not
Get the information and then let me know.
lordship, yes.
Don't come up with a half.
My lord, duty is to inform you, lordship, my lord. As per my lord, rule.
Whatever may be, when did he die?
Well, date is not, my lord,
Then
given.
your duty is to
Yes,
inform
I-
this court
I will
as
inform with full
when,
information.
no, Mr. Counsel, your duty is to inform this court if you had appeared on behalf of the respondent number 2.
Lord.
Did you appear on behalf of the respondent number 2?
No, lordship,
Then-
because he has already died. Lord.
Then, if you have not appeared on behalf of the respondent number 2, we will construe that you
Then I will
nobody
inform my
appears.
lordship, I'll collect the date, lord.
Let us see as regards whether steps upon respondent number 2 has been complete.
Has been 1, 3, and 4 not complete.
No, steps is not complete.
1, 3, and 4 is not complete. 1, 3, and 4 is not complete. Because they have purposely not appeared, but they are saying.
The Lozima court by the order dated so and so had directed the petitioner to take fresh steps for service upon the respondent number 1 to 4 by registered post with AD as well as usual process. However, till date, no steps have been taken. This is on 17/2/2024. 18 fixed on so and so for affidavit. So and so additional affidavit has been filed. Then
Again, I have to take steps.
steps have not been taken. Hey, second file. Where is his wakalatnama?
I have and one was filed, one was filed on my lord.
Who is Murshidar Khatun? Huh?
I don't know.
Sohar Ali has been received by one Murshidar Khatun. Khatar. Who is he?
I'm not aware.
Then how did you appear?
My lord, I am for one, my lord.
How did you appear? Have you not served? When did you appear? You don't find any wakalatnama also.
My
You.
lord, the notice was for, my lord, received by the 1, 3 and 4. Lord. Notice was received by the respondent numbers 1, 2 and 1.
We don't
1,
find your
3 and-
wakalatnama also.
My lord, Vokalatnama file loss.
When?
Lord, 18th of April 2024. One is 18th of April and other is lordship. 27th of March 2024.
Nahi kya wakalatnama nahi the?
My lord, a copy was also served lordship along with the notice.
No, because wakalatnama card. One book kita. Oh no.
My
Your
lord,
wakalatnama is not here.
my lord.
Huh?
This is the service copy lordship.
The step lordship I have taken in the year 2020, lordship. 21/10/2020.
Oh, you filed it on 18th.
One is 18th and other is 27th of March. Lord. For respondent number 3, it was on 27th of March and 1 and 4 on 18th. lordship.
Okay. I agree. What is that?
My lord, service copy, my lord, it was served. My lord.
Mr. Emmett, the learned counsel, submits that he had filed the wakalatnama on behalf of the respondent number 1, 3, and 4. The learned counsel further submits that all the respondents are brothers. Brothers, na? Are brothers.
Others, lordship.
Are brothers. On that basis, it has been submitted that the respondent number 2 had expired. He, however, is not aware as with regards the date of death of the respondent number 2. The petitioner is directed to take appropriate steps in the matter. To list the matter after 2 months.
All right.
Yes.
It is in court number 1. Kindly this time the phone, right?
No.
In another series of same petitioner, same respondent shared driver is pending. Total 20 numbers of only 3 is listed. Kindly list. This is your file. And engage counsel, please not available. Easy sir is busy in court number 1.
So what?
I'm not prepared. The same petitioner, same respondent, and same status, 20 number of these. Only 3 is listed. Maybe listed altogether, but
in the matter of the
can status.
the
Friday or
learned
next week,
counsel appearing on behalf of the petitioner in the three revision application submits that along with the said petition, there are there are 17 other revision applications so filed. He has the numbers of the said revision applications are a number. Taking into similarity of the facts, these matters on Friday. Friday 26. All in all cases same.
Same, my
I'm
lord. Same
appearing in
respondent.
8 cases. I'm already appearing in eight cases. I'll take instruction and file wakala.
Well, all are to be dismissed.
Procedural.
Hmm.
Chief, I am appearing for respondent number 1.
Hmm.
This they have filed for condonation of delay of 23 days.
How many respondents are there?
Respondent, there are 6 respondents.
Then
And subsequently, they have filed 3 petitions for some modification in the cost title regarding respondent number 2.
is the service complete? The registry shall list the matter again on 1st of May 2024. By making clear endorsements as to whether the service upon all the respondents are complete. All are appearing?
All are appearing. LCR
LCR received, service being complete and the LCR received.
my lord.
Let the matter be listed for
My
hearing in its usual course.
May I please? I am appearing for the 1, 2, and 3, and 6, 9, my lord.
And what about the others?
Last I have not filed Pokala Tama. Last was 18, 11, 22, lordship. Order is there, lord. The use F, so yeah.
And her service being complete and the records having been received, list the matter for hearing in its usual course.
Interim is there.
Hmm?
Interim is there.
Now I,
Order is 5, 10, 20, 20.
because I can like 1561. This is an application for stay of the judgment and decree dated 26/2020 passed by the learned additional district judge Kamrup Amingaon in title appeal number 06/2017. This court had duly taken note of that by an order dated 5/10/2020, the appeal has already been admitted by formulating a substantial question of law. Further to that, as the LCR and have been duly received, and this court have fixed the matter for hearing This court is of the opinion that the interim orders, which was the order dated 5/10/2020 passed in the instant application, is required to be made absolute till the disposal of the appeal. Accordingly, the operation of the judgment and decree dated 26/2020 passed in title appeal number 6/2017 by the Court of the Learned Additional District Judge Kamrup at Amingaon shall remain state till the disposal of the instant appeal. I stands disposed. You are appealing for everybody?
No, my lord. I am appearing on behalf of respondent number 1A to 1F. Main respondent.
What about 2 and 3? What is the performance?
Yes, my lord.
Well.
Perform.
The record reveals that the LCR have not been received. The registry shall take they'll take effective steps in that regard and list the matter immediately upon receipt to the LCR.
Most probably.
Yes.
For
What about the steps on view of performer respondent number 5?
performer respondent number 5 is a resident of USA, Your Lordship.
Huh?
The resident of USA, Your Lordship. Despite our best efforts, Your Lordship, we could not trace out the
Performer respondent number 5, is it necessary? Did he participate in the trial?
no, Your Lordship. No, Your Lordship.
So we strike out the name. Not necessary. Did the performer respondent file any written statement? Only the defendant filed.
Yes,
Okay.
defendant has filed.
Huh?
Only the
Good stuff.
defendant.
Others are appearing.
My lord, I am appearing for 1, 6 and 7.
1,
6 and 7.
1, 6, and 7. Who is appearing for 2, 3, 4?
Lordship, it is still
My lord, as
the
per
80
office
cards,
note,
neither the 80 cards or answer notices has been received back in respect of 2, 3, and 4. It reflected office notices 4, 3, 2004.
The records does not show as to whether the service upon the respondent number 3 and 4 is complete. So, be that as it may, this court finds it relevant to take note of the submission of the learned counsel appearing on behalf of the appellant that the performer respondent number 5 did not participate in the suit. So, under such circumstances, the name of the performer respondent number 5 is struck off. So, list the matter after completion of service upon the respondent number 3 and 4.
okay.
May it please, your lordship.
Hmm.
Lordship, this matter may kindly be taken after 26, any date.
After?
26, lordship.
Why?
Mr. H.M.R. Chaudhary, lordship, kept the file in his chamber, lordship, and 26 there is an election. He is returning on 26th night, lordship, so any date. Next Monday also, if you lordship.
Landlord tenant issue, Lordship, I am for the tenant.
And for that not filed an I.
Hmm?
Filed an IS stating that after receipt of the digital amount.
After?
Digital amount. What was decreased in the suit, we have not received any rent. And based on that, I have paid for vacation of the stay order.
And we have prayed that if any order is passed, Lordship, we are ready to pay before this registry also. Then we are ready to pay as per our affidavit in opposition. Lordship.
But as per the respondent's instruction.
What is your prayer?
There is for vacation of the stay order.
Who has got a stay?
Lordship, we are the
Petitioner
petitioner.
side.
You are the petitioner.
Yes,
You are
Lordship.
the respondent.
Yes, Lordship. She filed the IA, Lordship. So she is on that set.
I isn't.
1965 of the 1000.
Where is the stay order? Where is the stay order? That stay order you have not enclosed. What you are asking for vacating?
What I have annexed to?
Where? Eighty.
Annexed
No.
3.
Annexure?
3. Page 74.
Okay. Now they are not paying any rent. You got to stay without the rent.
Lordship.
Lordship, we are not inclined to receive. I have taken instruction because as the execution is pending, so there is a judgment also of this honorable court. So based on that, my submission is that Lordship, during the pendency of the entire proceeding, if the tenant doesn't pay, even if he has not submitted any rent in the court also, so we want vacation of the stay order. That is my second. Because we are not inclined to receive any rent. I have taken instruction order. Because the conduct of the petitioner in entire proceeding entirely was that first notice was issued in the year 2017. He has filed a reply stating that he needs 3 months time to pay an installment, but he did not. Subsequent to that, we have sent a notice. He also not complied with. Thereafter, suit has been filed that's been decreed in our favor, and defendant himself did not reduce any evidence in the suit.
Tenant, no evidence.
No.
It's a case of defaulter.
Yes.
Oh, matter
That has
finished.
been established.
Your Lordship can dispose it upon next week. Any day.
Right now.
Uh,
Right now we dismiss it. Hello.
Defendant number. Defendant.
Yes,
himself
yes, madam, come, please come this side. It becomes easier for me to dismiss. Yes, yes, yes. Yeah. Hello. No evidence. Case of defaulter. Then matter.
As per request of my learned friend, matter may be hard. I am not.
What is there to hear? Isn't that hearing enough? Landlord, tenant, what is the same thing? There's nothing more than that. I've stopped writing so much also in these type of judgments. 1 page is enough.
On Monday, your Lordship gets to stay.
No,
Your Lordship
no.
is sitting entire month. Lordship.
Huh?
Any date, Lordship. next week.
No. This has to go. Your suit is for, what is your ground?
Lordship. Today, the file is not with me. I am.
Hello, we vacate the interim order. The petitioner has approved,
We are
come
ready to
without
pay.
a file. You want that vacating?
Yes, sir.
Okay, we vacate it. We'll hear it after in 2034. What is your ground for vacating?
Ground is that after receipt of the decretal amount on 8/2/2019,
Mm.
thereafter several notices have been issued. But the defendant, the tenant, on behalf with the help of the stay order, he has not accepted any of the notices annexed to court series, your Lordship.
Stay order from High Court.
Yes, yes, your
Regarding
lordship.
notice, lordship, before institute of the suit, as per my landed.
Subsequent
No,
to that
no,
also
no,
we
no.
have.
Wait. First of all, against that appeal, these proceedings have been initiated, CRP 75.
Lordship.
CRP 75 is against what order?
Yes, first appellate court judgment.
Yes, your lordship.
Concurrent
Both the
finding,
judgments have been taken. Trial and appellate, your lordship.
Lordship, kindly go through page 63,
Wait,
the
wait,
finding of the first
Await
appellate
service
court.
report, issue notice, steps by. Oh, I didn't give a stay. I remember. Now,
Yes.
yes.
Your lordship has issued notice.
I issued notice but no stay.
But-
Await sir, it is hereby directed that further proceedings pending shall remain stayed until further orders. So now we pass the order of vacating it. Hmm. Chalo. See,
Next week, any date, lordship.
we vacate the order. Madam, all along you have been appearing.
Lordship. File is
Why
already
do you
with-
need HRA Chaudhary for?
No, Lord, not HR Chaudhary, lordship. HMR Chaudhary.
Who is he?
He engaged me in this case and the file is with him, lordship. Mr. HMR Chaudhary.
And what is he doing?
Lordship, he has gone to Hyderabad for the.
Lordship, I have a judgment. May I submit it?
For what?
On the basis of the conduct of the tenant during the pendency of the proceeding, if the tenant doesn't pay any rent or even he does not submit in the court also, then this he is liable for ejectment.
Madam, there is no
2001
quarrel with the proposition. Forget about the ejectment. The question is, I want to dismiss the proceeding. But the question is, can I do so or would it be reasonable to do so when she says that she is handicapped?
Ma'am, under your lordship, I have no.
She's showing out there that she has only a list, not the file. The cause list only.
Lordship, she has settled down.
Huh?
Just now, she has settled down.
Yeah. So then do you have a judgment for? Okay. Miss S. Dasgupta appearing on behalf of the respondent, oblique the applicant herein, expresses great urgency in the matter, taking into account that the petitioner herein had obtained a stay in the instant proceeding, stay of the execution proceedings, and how also, and have not even during the pendency of the suit as well as the appeal proceedings, including the present proceedings, have tendered any rent. She further submits that this has brought great prejudice to the landlord. She further submits that this is a case where there is a concurrent finding of fact
Yes, sir.
of both the courts below that the plaintiff, that the tenant is a defaulter, and though it is the burden of the tenant to prove, there is no evidence adduced by the tenant to show that the tenant have discharged his burden. His burden. So, taking into account it is the opinion of this court that this matter requires an urgent disposal, and accordingly this court fixes the matter on 30.
I pray for Monday or not.
Why?
We have some urgency in this matter because.
I'm fixing it on Tuesday.
Matter.
Cut off. No, cut off. Ms. R. Chaudhary, the learned counsel appearing on behalf of the respondent, petitioner submits that Mr. A, that the assisting counsel had taken the file and the file had not been given to her, and she is not in a position to argue the matter. Just list the matter after 3 weeks.
No, Lordship, on 30th, your lordship.
Absolutely no. When I give you, don't take a
Then
things
in that
for
case,
granted.
say date may candidate fix.
Right.
We-
No course fix dates. I only fix dates.
Then on,
And I don't
on
want to
30th,
do
your lordship. I'm
What?
extremely sorry.
No, absolutely no. Okay. Is the matter on 10th of May.
Much obliged.
20. May please, Your Lordship. As per office note dated 22/3/2000.
What is this I for?
I for condonation of delay of 25 days. But the
And substitution?
substitution, pro forma defendant has died, a pro forma respondent has died, and one of the respondent number 4 has died. So 7, 4 may be struck off.
What?
Pro forma can be struck off.
What is this application for?
Condonation of delay.
How much days?
25.
I mean, you should notice.
Has
Has anybody appeared?
No, no one has appeared. But service on
Is the service complete?
1, 5, and 6 is complete.
Addressee expired.
Yes.
Then what happened?
Address is expired.
No substitution application filed.
We have not received the date.
No, no, you can't help it then. We'll go for abatement. As regard respond number 4 to 7.
Not 4 to 7, 4 and 7.
Huh?
4 and 7.
4 and 7.
Yes. 5 and 6 has AD card has arrived with the signature of one Sangita.
Who is 4 and 7? 7 is okay, performer respondent. Who is 4?
4 is
Is the plaintiff.
Is the defendant, one of the defendants.
And you filed a suit against them.
Yes.
Did he win the case?
We won the case. It was decreed. Thereafter, they filed an appeal. That was delivered.
And what is the degree appeal filed?
Appeal was filed.
Appeal was filed by respondent number 4 also?
Yes.
And the appeal was allowed?
Appeal was allowed.
So under such circumstances, if we hold that the appeal has abated against the, or you don't want to press against 4, that judgment passed in favor of the respondent number 4, along with the other, attains finality. And if it attains finality, the instant proceedings abates. So we accordingly dispose of the main matter. Then why are you making such a type of submissions? Mr. S. Dr. Counsel appearing on behalf of the petitioner seeks some time for taking appropriate steps in the matter. It's the matter of the focus. You will be in deep trouble.
Please, Your Lordship. Lordship, as per
Record reveals that the LCR of title suit number 42/2016 have not been received. The registry shall obtain the said shall requisition the LCR of title suit number 42/2016 and list the matter upon receipt of the LCR.
I'm for the sole respondent. I'm appearing for the sole respondent.
Fantastic. Give your name. What is this?
Matrimonial appeal has already been.
Yes. Who has filed the appeal?
Wife.
You have filed the appeal. Now you have filed an IA. You have given a copy to him.
I'll supply.
Then how do I pass an order? The learned counsel appearing on behalf of the. Now you are the sole appellant?
Yes, yes.
A respondent?
Yes.
Okay. The service is complete. In as much as the respondent is duly represented. Mr. H.K. Sharma appears on behalf of the appellant and submits that there is an interlocutory application filed. Mr. So-and-so appearing on behalf of the respondent submits that no copies of such application has been furnished to him. Taking into account the above, this court directs the counsel for the appellant to serve a copy of the application to Mr. So-and-so during the course of the day. List the matter again on 3rd of May. Service complete. Service complete. LCR received. List the matter for hearing in the usual course. Yes, service complete
Yes, my lord.
and LCR received.
Not received.
So ये क्या go to hearing? Oh, that matter.
Lord.
Very well. Yes, tell me what is the case?
Lordship, the respondent filed a manuscript against me. And it was expertly proceeded against me by the order dated 21/12/2021.
Suit proceeded ex parte against you.
Expert against.
Then
Thereafter, I filed an application for under order 9 rule 7.
Okay.
Along with that application, section 5 of limitation act application also filed.
you filed.
Lord.
Okay, then
Both the applications were rejected.
and why are there two matters?
Two separate cases were registered and two separate orders were passed.
Fantastic. Good resources for the councils.
Because they two orders passed separately, I have to.
Anyways, you filed your written statement.
On the day of filing of written statement, I was proceeded expert.
Oh, is it that case? Where's that order?
Order page 50.
Hmm?
50.
50. How many days? It was some 30 days or 60 days, 90 days was not over or something like that.
No, Lordship, what happened, Lordship, earlier, there are other defendants were also there, pro forma defendants.
Hmm.
The pro forma defendant, one of the pro forma defendants appeared, Lord.
Hmm.
And I was the main defendant.
Hmm.
And during the
And when did you file that application?
I filed the application, Lordship, on page 76, Lordship, on 7/9/2023, Lord.
Hmm?
7/9/2023.
7/9/2023.
Yes.
Why so late?
Lordship, earlier I did not have the knowledge, Lordship. And because
You were ready with your written statement on that date.
no,
It proceeded ex parte against you.
yes,
Why?
because I did not appear earlier also, Lord.
Understood. Did you receive the summons?
No, Lord. I am residing at Guwahati, Your Lordship, for my vocation, Your Lordship.
Hmm?
I am not a resident of Chipsagar, Lord.
Where is the order by which summons have been served?
That order, Lord. That order is summons order is not there. Kindly see page 26, Your Lordship. Summons was not served upon me, Your Lordship.
Huh?
Page 26, Your Lordship. First order, Your Lord.
Wait. Which is that order you said, which was gone against you?
Page 50.
Page
50.
50. Yes. Now. Then Corona set in. Then when was the service complete?
Lordship, service, there is no service on me, Your Lordship. Summons was not received, Your Lord. Then page 28, fixing for appearance and hearing, Your Lordship. Order dated 3/12/2020.
Where is the order by which service is complete? There is some order somewhere. Yeah. Page 17/3/2021, page 34. the copy of the plaint was given, directed. Then you duly appeared on 17-3.
Lordship, what happened in this case, Lordship, Proforma defendant number, Proforma defendant, the Oboni, what have Lordship, who was my father, your Lord. At that time, he was bedridden. During pendency, he expired.
Hmm.
He might have engaged one counsel, Lordship, but I have collected the certified copy of Wakalatnama. I have seen that I have not signed the Wakalatnama, the present petitioner. And I have not received also some.
Yes, what do you say?
The same counsel has appeared for the father and the son.
Yes, father is the different person, son is a different person.
Different person.
Father is in heaven, son is on earth.
Yes,
Then-
but in their petition, they have not said that he has not authorized his father or he has not.
No, was he a party
Yes,
in the suit?
suit.
Yes, I am main
He is the
defendant.
main defendant.
I am
No,
the
no,
main-
why was the father appointed?
Actually, my lord, father's
Father was a
party
performer
Proforma defendant.
agreed to be solved.
because both reside at the same place.
No, Lordship, I am residing at Guwahati since my vocation, your Lord. And the
Address is shown as different.
the address is.
But
shown-
why this person, the court have recorded the defendant could not come to court as he is residing at Guwahati?
Lordship, that is what my father might have appointed that counsel, and he might have instructed, but I did not. Lord.
Did he say all these things? But you didn't sign the Wakalatnama.
Yes, your Lordship.
What is the name of that learned counsel?
Tenant counsel, Lordship.
Thereupon, why the matter was again fixed at
Oh,
page 50 for filing of the written statement?
It's because Lordship, in between my father, petitioner's father died, and they prayed for substitution. There was delay, Lordship, and limitation petition was there, and accordingly they proceeded some time.
But he was the performer defendant.
Yes, your Lord.
Then why was the substitution required? So the suit was stayed.
After death of performer defendant, suit was stayed and fixed for substitution. Your Lord.
So when did the performer defendant die? Because earlier orders showed that somebody had died.
Yes, your Lordship,
Performer
kindly see, after order dated 23/12/21.
Anyways, then what happened?
Then your Lordship, kindly see next page, your Lordship, page 52. Page 52. However, in order to frame the points of determination as this court perused the case record, it has come to the notice of this court that the performer defendant late Kavuni Bhattakur passed away and to file a petition to substitute his legal heir. A condonation of delay petition. A condonation of delay petition under section 5 of Limitation Act by number plus 5.
And when did you file your application?
7/9/2023, Lordship, at the stage of argument, your Lord.
Huh?
At the stage of argument.
You knew all this while. You didn't know anything.
No, Lord. Because I lived here and I lived at Golaghat, your Lordship, with my family. Separately, we resided. The plaintiff,
You reside in Golaghat.
Golaghat, your Lord, with his wife and children, your Lord. And in between, the suit was transferred to one court to another court also, your Lord.
How did you know about the passing of the order?
Lordship, about the passing of the order, one of my relatives, your Lordship.
Anyway, whether any substitution was carried out?
Yes, substitution was carried out and expective order was passed against them
No, understood. Whether summons were issued?
for substitution.
Pursuant to the substitution, summons have to be issued.
For
Was it issued?
substitution, that part not yet.
Yes, Mr. Sahu. When was the substitution carried out?
Substitution petition, yes, your lordship.
Notice issued to legal representative has not returned. Wait, 13th May. 20 when the heirs of so and so. Yeah. Case record put up today and Iman, appearance of the Iman. Plaintiff and the legal heirs of the are represented on 24th of June. How is it possible? Then.
At page 52, notice was issued.
That I've seen it.
At page 58, somebody has appeared on behalf of the.
Now, where is your allegation that the lawyer appeared without your intimation in your application? Page 76. Or your where's your other application? The other application is here.
Yes, your lordship, next 26 item number.
Huh?
Item number 26. That the petitioner never received any summon in the aforesaid suit and has said.
No, where? Page
77, your lord.
Yeah.
The petitioner defendant had never received any summon in the aforesaid suit and as such, due to non-service of proper summon, the petitioner was unaware about the pendency of the suit against him. The suit was as such left to be properly defended by the petitioner defendant due to such improper service of summon against him. That in the last week of August 23, the petitioner defendant first had heard about the pendency of a suit against him in Sibsagar Court from his.
Now, where is your allegation that the lawyer appeared without your ear?
That part is not
Then-
there, your lord.
Then that is the most vital thing.
But I have lordship one after filing of this, I have
What is the suit for?
suit money should your lordship.
How much?
5 lakhs.
5 lakhs.
5 lakhs. Lordship, to my father, Proforma defendant, and the present petitioner, an agreement was executed between the Proforma defendant and the petitioner. But
And the
Proforma defendant and
the plaintiff.
the plaintiff. But in the agreement, their signature of one only defendant is signature.
Your signature is there.
Yes, your lord.
But the agreement is with the performer defendant.
Yes, your lord.
The agreement with his son to be sold the land belonging to father.
That
So at
lordship,
that time,
part of
the
marriage,
son
your
was
lordship.
not, had no right.
Father,
Probably. But later on, they decided to, because he could not transfer the land, that is why we asked for the money, the advance amount what I.
property is in the name of father, your lord. And agreement was executed, but later on due to some.
But Mrs. Tom, unless you make that serious allegation against the lawyer, because the lawyer did not have the authority to appear.
It is not there in the
So,
petition.
and if you don't say that, but the lawyer duly appeared on that date, then how do I help you?
Lordship, the suit lordship at the stage of argument, your lordship. Your lordship consider that part, your lord.
So what? You want to argue that?
Lordship, at the stage of written statement, your lordship.
You want to bring back to the stage of written statement which happened for such a long time and thereby make the suit another 10 years, 5 years.
Lordship, Lordship may direct that within a expeditious period, Lordship.
Huh?
Within a time,
Because of your fault.
not only that, Lordship, for the
It's your fault. Because of your fault, this court should direct the trial court to keep up all other matters
No, Lord.
and
I am not
concentrate in
submitting that.
disposing of your suit, these suit within 6 months, and you will file your written statement. Although you don't make an allegation against that.
Lordship, because Lordship, if I get the chance to file written statement, Lordship, I'll have to.
No, you knew
take
it
and
very
file
well.
this here, Lordship.
Your father must have 100% informed you. Your brothers must have informed you. That's the not natural course of offense.
That is Lordship.
Then
but,
why you are saying that you
yes,
did not
yes,
know? Are you
yes.
not in good terms with your father?
That is what your Lordship. As per instruction, your Lordship, he is residing at Guwahati and separately residing
Mr.
at
Counsel,
Lordship.
are you not in good terms with your father?
Yes, your Lordship. That is the instruction, your Lordship, because they are separately residing due to marriage with the petitioner. They are not happy, your Lordship. So they were separately residing.
And then when you are not in good terms with your father, you entered into an agreement with the plaintiff
Between-
for sale of your father's land. Did you file a 420 case against him? Or not?
No, that
File.
that has not been.
No,
filed.
no, not file, not
No,
file.
no, immediately file. This is a good case. And he may lose his job out here. He's working out here
Here,
in the High Court.
Lord.
I think this is a high time. And they put it before the registry.
Lordship, only
This is a
considering
very serious thing which you have done.
the
No, there is no considering. It's on the face of it. It's improbable. You dismiss it. Not worry.
Lordship, considering the judgment of Lordship by Supreme Court at the stage of original judgment, your Lordship.
What does he say?
Before judgment, your Lordship may consider that part.
Which one?
To appear, Lordship.
You want to appear just and argue.
It is
You appear and say about the falsity of the case. That you can do. But nothing to do with anything. You see, the provision of Order 9, Rule 7, if allowed, will put the clock back to the position.
yes.
That can't be done. You may participate in the trial, whatever has happened at present. And you may ask for whatever may be. This is for only for filing of the written statement.
Yes, your Lord.
Yes. So you do whatever you have, but this court is not going to interfere with this. Look,
Lordship, at the stage of WS, it was expert, your Lord.
in the next utterance of another word is a cost upon Mr. A.R. Som. No more further. I'm coming in 5 minutes. Mr. A.R. Som, the learned counsel appearing on behalf of the petitioner, and Mr. S. Sahu appearing on behalf of the respondent number 1.
vote, my lord.
2.
Vote,
1 and
vote.
2. Both the applications under Article 227 of the Constitution are taken up together for disposal, taking into account that both arises out of the same suit proceedings. It revealed from the records that the respondents herein have filed a suit being money suit number 44/2021 before the court of the Munsif number 2 at Sipsagar, wherein the petitioner was arraigned as a defendant and his father was arrayed as the performer defendant. Full stop. In the said suit, as is apparent from the records, the petitioner appeared on 17th of March 2021 and sought for time for filing the written statement on the ground that the copy of the plaint was not furnished to him. Accordingly, the court, the learned trial court, that is the court of the Munsif, number 2, Pipsagar, directed the plaintiff to serve copies of the plaint along with the documents, if any, to the counsel appearing on behalf of the defendant oblique the petitioner herein. The record further reveals that on account of the COVID restrictions and the death of the performer defendant, proceedings were initiated for substitution of the legal representative of the performer defendant, as well as also for which the suit got delayed. On 23/12/2021, which was the date fixed for filing of the written statement by the defendant oblique the petitioner herein, the defendant did not appear, and consequently, the court, the learned trial court, proceeded ex parte against the defendant oblique the petitioner herein, and fixed 21/2/2022 for framing points for determination. However, on 21/2/2022, on account of not taking steps for substitution of the legal heirs of the performer defendant, the suit proceedings was stalled, thereby directing the plaintiff to take appropriate steps. The record further reveals that the steps were duly taken and the legal representatives of the performer defendant were duly arrayed as parties. To the said suit as performer respondent. The performer defendant number 1A and 1B. However, the performer defendant did not file any written statement for which the suit proceeded and was at the stage of arguments when two applications were filed. The first application is an application under Section 5 of the Limitation Act for condoning the delay of 622 days. And the second application was for the purpose of setting aside the order of passing ex parte. That is dated 21/2/2022. The learned trial court rejected both the applications by the order dated 16/9/2023. And it is against that the two revision applications have been filed before this court. In the backdrop of the above, this court now finds it relevant to take note of the submissions made by the learned counsels appearing on behalf of the party. Mr. A.R. Som, the learned counsel appearing on behalf of the petitioner in the two revision applications, submit that the petitioner never authorized any counsel to appear on the behalf of him, and the petitioner even did not receive any summons. It was only at the stage of arguments the petitioner somehow came to learn about the pendency of the said suit, for which the petitioner filed those two applications which were rejected by the learned trial court, and against which the two revision applications have been filed. Mr. S. Sahu, the learned counsel appearing on behalf of the respondent numbers 1 and 2, submitted that from a perusal of the applications, it would nowhere be seen that the petitioner had taken any such ground that the petitioner did not authorize his lawyer to appear on 18th of March 2022. 18th, what is the date? 18th of March.
Seventeen March 21.
On 17th of March 2021. Good stuff. The learned counsel submitted that the performer defendant, the learned counsel submitted that a perusal of the suit would show that the suit was filed for recovery of money of rupees 5 lakhs, which the petitioner, which the defendant oblique the petitioner herein had taken as advance from the plaintiffs to sell the land of his father, that is the performer defendant, father, who was the performer defendant, this late Oboni Botagut. The performer defendant not only represented in the said proceedings, had represented in the said suit proceedings when he was alive. Even the substituted legal representatives have also appeared and did not file any written statement. He submitted that the petitioner very well knew about the entire proceedings throughout and is just making an excuse before this court, for which the instant petition is required to be dismissed with exemplary costs for abusing the process of the court. Next. Upon hearing the learned counsels appearing on behalf of the petitioner, as well as the respondent, and also on perusal of the materials on record, it reveals that there is no such allegations so submitted as submitted. There is no such allegations made in the application seeking vacation of the ex parte order, or even in the application for condonation of delay, that the petitioner did not authorize the earlier counsel who represented him on 18th of March, 17th of March 2021. This court further finds it relevant to take note of that the father of the petitioner very well knew about the instant proceedings, including his brother and his sister. It is completely not believable that the petitioner was not aware of the said proceedings. That too when he was duly represented by his counsel. This court further finds it very pertinent to mention that the order was passed on 21/2/2022.
23/12/21.
23/12, no. 23/12.
Yes, ex parte order.
23/12/2021. And the petitioner did not take any steps till the suit was fixed for this at a stage of arguments, isn't it?
Yes.
Under such circumstances, this court, having perused the impugned orders passed by the learned trial court, that is, the order dated
16/9/20.
16/9/2023 in Ms. case number 113/2023 and
112 of package.
And of the same day, and the orders dated 16/9/2023 in Ms. case number 112/2023 and Ms. case number 113/2023 does not find any reason to exercise the jurisdiction under Article 227 of the Constitution in the present facts. Accordingly, the instant proceedings, both the petitions, stands dismissed. Be that as it may, before concluding, this court finds it relevant to observe that the rejection of the applications so filed by the impugned orders which have not been interfered by this court shall not act as a bar on the part of the petitioner to appear before the learned trial court in the suit proceedings from the stage as it presently stands. This court, next. This court, by the orders dated 8/12/2022, by orders dated 8/12/2023 in CRP IO number 409/2023 and 5/1/2024 in CRP IO number 411/2023 had stayed the further proceedings of money suit number 44/2021 pending before the Court of the Civil Judge, Junior Division, Sibsagar. Junior Division number 2, Sibsagar. Both the orders stands vacated and the parties being duly represented are directed to appear before the learned trial court on 3rd of June 2024 for further proceedings of this.
Obligable.
May I please, Lordship? I'm for respondent, Lordship.
What is this IA for?
And for 360 days of delay in filing this second appeal. 360 days delay in filing the second appeal.
Okay, why?
Lordship, I was not aware of the first appeal that was filed that was going on in the assistant district and session judge
You was past ex parte?
ex parte.
First appeal is judgment?
First appeal judgment ex parte. I was not aware.
The trial court?
Trial court also ex parte, but it was in favor of
Okay. The first appellate court judgment was also ex parte.
ex parte, but it was against.
How did you know?
Uh,
Money execution.
Money execution was filed in 21/3/2023. I received a notice about that.
And then
And then
you filed the appeal when?
appeal on
Oh.
25/5/20.
You are appearing for?
Respondent number 1 and 2, Lordship.
How many respondents are there?
2, Lordship.
Okay. We condone the delay. It was proceeding ex parte, the judgment.
Yes, Lordship.
This is an application for condoning the delay of 360 days in preparing the appeal against the judgment and decree dated 27/1/2022, passed in Money Appeal number 1/2019 by the Additional District Judge, Gwalpara at Gwalpara.
May
The
I please,
re-
Lordship? Lordship, in this Lordship appeal, the respondent appeared, Lordship.
Prepared?
Yes, Lordship, but in the judgment, the respondent's advocate name is appeared. So, Lordship, in the appeal, they have appeared, Lordship. Kindly produce the judgment of appeal, Lordship. Because, Lordship, judgment was passed 27/1/2022, and the respondent's advocate M.
In this case also you have appeared, suit also you have appeared.
Yes, Lord.
I have appeared and we have filed a WH. After that, it continued ex parte.
No, in the respondent appeal. Why did you say that you are not appeared?
The advocate appeared, but we were not informed as a part.
How? How is it possible? You were not informed.
There was no communication between me and the advocate because the advocate was appearing earlier. Also, he appeared on behalf of me in the money.
See, page 32 of your memo of appeal. I've heard the argument advanced by the learned counsel for both sides and have gone through the pleadings, evidence on record, and the impugned judgment at length. Page 32, have you got it?
Yes.
Then, how can you say that it has gone ex parte? Did you give him a mukalatama?
As for the judgment, It was not expertise as such, but she was totally unaware about the judgment and the decree dated 27/1/20.
Why?
Because the learned advocate nor anybody else informed me about
Where is the allegation in your application? Huh? Oh, yeah, you have made it. Who is the advocate? MMA? What action have you taken against him?
after receiving after getting to know about the money execution proceedings filed against me, I have appealed before this court. That is the first action that I have.
No, you can't blame the lower court counsel like that. This court doesn't allow. What action? File a complaint before the bar council against him. Bring it by way of an additional action. Then we'll keep it pending till the bar council decides. Then we'll condone. I'm not going to do. You can't blame your fellow counsel. But Mr. Counsel, I'm very disappointed with you. Why did you mention it to be an ex parte?
Really, the judgment was.
We trust what the lawyer says. But this is not what we expect. Yes, what is your name?
Ahmedabad.
Naam to wrong agi double likhi do.
I'm extremely.
No. You see, once you do it, we will never believe you. From next time onwards, whenever you say something, I will double check it. Because you made a very blatant mistake.
Accidentally.
The moment you said that, I was about to allow. Luckily, he said that.
It was just.
And you have blamed the council.
I have
The council did not inform about the judgment. How is it possible? How is it possible that the council, you have engaged the council? Then, the judgment, are you aware of the civil rules and orders which says that a judgment is to be delivered in the court? One, it will be not only delivered in the court, it will be also delivered on the date which is given out there. Yeah. And it is not like in a high court where there is only one day the matter is fixed and after that it will come up here. Every month there is a date. In the trial court, are you aware of the fact that, or in the first appellate court out there, are you aware of the fact that the councils on every day take money? That's the fees which they are taking. If that be so, isn't it the duty of yours to ask him, what is the next date? Are you telling me that the learned counsel have done the hearing of the appeal on a date when it was that too without fees? Well, this is a false statement by him, unless this is not being proved. And I'm very serious on this. You can't blame the lawyer like this. You're right, whatever may be. Oh, this has nothing to do. You can't blame the counsel. Unless I can only give you an opportunity provided he gives an affidavit. That counts. That yes, I failed to inform the counsel. Then only I can confirm. Otherwise, I'm not going to. Can you get that? This court had perused the application filed under Section 5. From a perusal of the said application, it reveals there are serious allegations being made against the counsel who was representing the appellant before the first appellate court, to the effect that even having due notice about the order passed on judgment and decree passed on 27/1/2022 by the learned first appellate court, the said counsel did not inform the appellant about the said judgment and decree, and it is only on 21/3/2023 the appellant came to learn about the said judgment and decree when a notice was received in money execution case number 5/2022. This court is not inspired by such allegations which have been made. Under such circumstances, this court grants a liberty to the applicant to provide necessary materials on record as regards the said allegations. List the matter again on when? How much time will you require?
4 weeks.
After 4 weeks.
Obliged, Lordship.
Obliged.
Here, I hope to take best of respondent number 1 to 7 except 2. Actually, I did not take this mistake on my part, so I may be allowed to take. Appeal was dismissed on the ground of abatement, Your Lord. The application to the file. Service of notice upon respondent na legal alert for respondent number is complete, but rest I have not taken steps.
What is the service status?
Actually, steps only upon the legal alert for respondent number 2.
2A, 2B have refused,
Team service.
and 2C, 2D, and E out of station.
Now, for last office note, they are served your
Mother accepted. So service is complete.
no longer.
Then
Respondent now, there are 7 respondents out there.
what about the others?
Others I have not taken. Mistake.
Why?
That is a mistake on my file, the filing clerk, Your Lordship. So I want to take that step. I may be allowed your.
Who died? Yunus Ali.
Yes, Your Lordship.
Is anybody appearing for them?
No, not yet.
Hello. The learned counsel appearing on behalf of the applicant submits that service steps have not yet been taken against the other respondent, the respondent numbers 1, 3, 4, 5, 6, and 7. He submits that she may be permitted to take appropriate steps in that regard. The applicant is directed to take steps by way of registered post as well as usual upon the respondent numbers 1, 3, 4, 5, 6, and 7 within 7 days. List the matter after completion of service. None appears on behalf of the applicant as well as the respondent on call. For the end of justice, the matter stands adjourned to be listed again on 25/2024 in time Please make clear that if on next occasion the applicant is not represented, the instant application shall be dismissed for non-prosecution. No. Yes,
About the delay condonation application, my lord.
what is this?
Second appeal.
Now, what is this IA for?
I have for delay condonation.
565 days.
Yes.
You file objection. What is the ground?
My lord, ground is that, my lord, earlier, the, against the decree, the suit filed by the plaintiff was dismissed. Then appeal was also dismissed. But part of the judgment is against the defendant that awarded sum of rupees 2 lakh without ascertaining the this is as a compensation. Against that, earlier counsel filed civil revision petition before this honorable court, and page 10 is the order of the civil revision petition. Then,
So this is the delay because of that.
no, thereafter, what happened? This was withdrawn.
Which one?
This civil revision was withdrawn. With
No, no, copy of the order dated 8/1. What is that?
My lord, kindly see page,
His liberty petition is disposed of with liberty as sought for.
yes.
Then
Then in the meantime, my client, my lord, he was as a psychiatric patient, he was treated at mental hospital at Tezpur for about 2 years. And when he recovered, came to Guwahati. In the meantime, he came to know that his earlier counsel also died during Corona. So ultimately, brief has been taken from the junior of that earlier counsel, and file has been handed over to me. Then I filed this second appeal.
So these 2 years you were in medical treatment.
No, Lordship, my learned advisor annexed the document as regards the medical Lordship.
These are all outpatient.
Only outpatient Lordship. And Lordship further, there were 4 applicants Lordship. There were 4 applicants. Only one of the applicants was under treatment Lordship. The 4 applicants Lordship, 4 brothers.
Who was on a Dilip Roy?
Dilip Roy Lordship.
What about the others?
No explanation.
They are actually in this case, they are not at all necessary party also.
Then why you are making them a party?
Because in the suit they are make part.
Why you are filing an appeal against them? File an amendment applications to strike off the.
But they are not.
You are saying not necessary. File an application to strike off. Then he may concede.
Lordship.
Whatever.
Lordship.
Because
Mr. S.K. Ghosh, the Appellate Counsel appearing on behalf of the. What do you do, Dilip Roy?
now it is not being.
At that point of time?
At that point of time, his house was, he was the tenant of my house. The house was gutted with fire.
What did you do
Now he
earlier?
earlier he was a businessman.
Who?
This Dilip Roy.
He was a businessman.
Business at that point of time. Now he is not doing anything.
No, not now. Now why he is not doing anything?
He is in Morigaon.
Huh?
He is in Morigaon.
What does he do? What does he do?
Now he is not doing anything.
His age as on now will be 64 years. What does he do?
Now he is not doing
Nothing.
his son is looking after.
So at that point of time in 2019, 18-19, did he do anything?
No. His shop was tenanted to given.
So you did not carry out any business?
Now at that point of time also.
18-19, nothing.
No, nothing.
So how did you survive?
My son is looking after.
So you were a mental patient.
Still, he is not recovered well. Not,
So what was your disease?
this is a psychiatric patient.
No, psychiatric contains many things.
Yeah.
What is the disease?
Actually, that
If it is too much, then
not,
obviously
not too much.
the son who could look after the business could very well
No. Son is
file
not-
an application
son is
as
not-
an expense.
Son is not doing business.
You were just saying now
No,
the
son is
son was
looking
doing
after-
business.
Son is doing work private company in Guwahati. Every day he is coming and going there.
So what
conducting-
business were you doing in 1819?
I was at that point of time. I have only a soft house which I have given rented to him.
So
on
you only survive on the basis of the rent.
rent. But it was gutted with fire. Then she filed a suit that possession be given to him as well as construction be made. That suit was dismissed. Then he filed an appeal. Appeal was also dismissed. But in appellate court says that since he was not given possession of the suit room, so 2 lakhs compensation has been awarded against him. Against that, civil revision was filed. So ultimately, this honorable court is that no, it is an appealable order.
Hmm.
That appeal.
Then
Then there is delay.
so tell me, if we see Annexure 3,
Yes.
the date of registration is 2012-2018. So as on day, you were mentally incapacitated?
No, it was not so. It was not mentally incapacitated. He was actually a patient of nervous failure. Sometimes he was well, and sometimes occasional he was mentally retarded.
But the tablets which are being given doesn't show anything to the effect.
And kindly see page 12 below.
Page 12 only I am seeing.
Yes, neuro.
It is something to do with nerves. Then
Next page Meta J fine.
so
Then
this is for sleeping.
Sleeping.
Then how does it have any change? Because that is another thing. Why I'm saying about the date 2012-2018. If that be so, the withdrawal so made by you on 25/9/2019 was a withdrawal being made without authority, a person who was incapacitated. And if he was not mentally incapacitated, then the natural consequences is he could have very well filed a suit. Appeal. Can't take this type of grounds.
But
And the other threes are not there.
The other three others are there, Lordship. And why they have chosen this
my lord, in
answer?
the meantime, my lord, in the meantime, the counsel who has withdrawn the case, he also died. During corona period. I could not able to collect the brief also. Ultimately, when I recovered, that is the appellant number.
You were always under a recovery. There is no problem with that. The ailment which is being shown does not inspire the confidence of this court. There is nothing out there.
But on
Just having a outpatient record of LGB, the Regional Institute of Mental Health does not make him a psychiatric patient, incapacitated to it.
my lord, kindly see the order of the appellate court, my lord. Kindly see on merit.
I am not going to say anything on merits.
Because there is.
Why have you made the others a party? Others are also liable to pay.
Lordship.
My lord, others are not liable because
Why?
rent was, rent
No, was the decree not passed against them?
decree.
Was the appellate decree not passed against them?
Kindly see the appellate decree, my lord.
How? I'll do it.
Appellate decree, kindly.
Yes.
At page 38, kindly.
Yes.
The appeal is dismissed on contest with court. Prepare a decree accordingly.
Hmm.
Send back the LCR.
No, before that, paragraph 22.
Now kindly see paragraph 22. In such premises, taking into consideration of fact that the appellant plaintiff is not in a position of shop already destroyed since long, the appellant plaintiff is not entitled to restore of possession of the said shop. This is also against him. Instead, it will be in the interest of justice if the respondent defendant is directed to pay a sum of rupees 2 lakh in favor of the appellant plaintiff toward compensation within a 3 months from today for depriving the appellant plaintiff from enjoying the suit property by constructing a new shop, either on their own volition or by allowing the appellant plaintiff to construct a new shop.
Then
Against this order, they file.
So why do you need to file? You put the finger upon the other three. You are only representing Dilip Kumar Roy. Others you are not.
But appeal filed by all of them.
So they have no problem. You see.
Why they have no problem, but suit property is of Dilip.
Did you file a joint written statement?
Written statement. Joint written. Suit dismissed, appeal dismissed. But how this the lower appellate court came to a finding of this 2 lakhs? There is no discussion, nothing. Compensation of 2 lakhs, there must be some discussion how this compensation comes.
And why didn't your son file it?
Son.
Number 4 is your son. Who was doing very well, good business outside, now giving you all benefits.
Dipankar Rai.
Yeah. He's your son. He could very well file it. See, it's a joint written statement filed by defendant number 1 to 4.
Joint written.
Then, have they mentioned anywhere in your written statement? See the verification. The verification is, which is that at page 16, is made by everybody. See page 16 top. The entire land has been partitioned amongst the defendant numbers 1, 2, and 3, and for which the defendant is unable to give any room to the plaintiff. Then this is your stand. And you are saying that defendant number 3, 2, and 3 has no business, 2, 3, and 4. How can you say that?
The suit property that is in question, that was in question, that fall in my share.
Where is it?
It was not at that.
Now it has fallen.
No, it was my share.
Where is your mention in your written statement? That is not your stand. Then, okay, we reject it then.
My lord, kindly consider that.
I don't consider nowadays. These have to be nipped at the bud.
Actually, the earlier.
Earlier is okay. Till 2001, 21, I'll admit. When did you file this? 23. Then 21 also Corona finished.
After Corona.
Corona finished in 2021.
22.
22 has gone. What did you do in 2022? Not a single document out here for 2022 also. See, the last of the outpatient records are 2021. What do you have time? How do you take care of that? These matters needs to be finished up at the meet nowadays. I consider till 400, 300, 350. Nowadays, again today, what the lawyer did, now I'm reducing it to 250. Very strict on it.
In the merit of the appeal, my lord.
There's no merits. Merits gone.
My lord, there is a 2
He
lakhs.
has lost. He has lost. You are paying 2 lakhs. How does it matter?
No, 2 lakhs, my lord. How came to a conclusion of 2 lakhs? There is no.
How he has come. The court
Only
thought it nice.
Justice.
The
2
court
lakhs.
thought it nice and did it. How do you take care of any day after in the year 2022? 2021, I take it. Okay, no problem. How do you take care of 2020?
Delay of lordship 565 days after discounting Corona period and lordship section 14 also. I have discounted that Supreme Court period, that period discounted.
Corona period discounted.
Discounted lordship and section
When?
14.
No. When was the judgment? When in 2018.
17 lordship.
No, 2019 he has withdrawn.
Withdrawn lordship.
19 to he has withdrawn.
Lordship.
February.
Lordship.
And then thereafter, let us assume that he has gone to mental health and all.
Nothing doing.
Then also the last of the document is about 8/3/2021.
8/2/21 lordship.
Yeah. Thereafter, give us again 2000 year till 28/2/2022.
28/2 lordship.
28/2/2022 we give him.
Then-
Then also he has not done
No,
so.
nothing, lordship. No explanation, nothing. Lordship.
No explanation. And your counsel died only during the COVID time.
Lordship.
So
Council died.
and there were not only one counsel. The next counsel was very much there from whom you could take up the file. And you got the file on 26/2023. Then what happened?
Earlier council art.
No, you got the file in 26/2023.
Yeah.
And then immediately you filed on 21/7.
Yeah.
When did you contact him?
My council.
Yes.
The junior of RJ Bartol.
When did you contact him?
On that day when he collected the file, on that day that part is not there when he has collected.
Nothing is there. Not satisfied. Now, you reject it. This is an application under Section 5 of the Limitation Act, read with 5, read with Section 12 of the Limitation Act 1963 for condoning the delay of 565 days in filing the accompanying second appeal. From the materials on record, it reveals that a suit was filed by the respondent herein seeking declaration of tenancy and restoration of possession of the rented premises on account of the rented premises having been gutted by fire. The said suit was filed which was filed, was registered and numbered as title suit number 91/2014. It is very pertinent to mention that in the said suit, there were 4 defendants who are the applicants in the instant application. In the said suit, the said defendants jointly filed a written statement denying the claim of the plaintiff. Full stop. It was the specific statement made in paragraph number 17 of the said written statement that as the land has been partitioned amongst the defendant number 1, 2, and 3, it would be difficult to accommodate the plaintiff by restoring possession. Be that as it may, the suit was dismissed by the judgment and decree dated 1/12/2016. The record further reveals that the respondent herein, as appellant, preferred an appeal before the court of the civil judge at Morigaon, being titled appeal number 3/2017. The said appeal was also dismissed, however, with costs. In paragraph number 22 of the said judgment of the first appellate court, it was observed that though the plaintiff was not entitled to restoration of tenancy as well as possession of the premises, but the plaintiff would be entitled to an amount of rupees 2 lakhs as compensation. Which was directed to be paid within 3 months from the date of the said judgment and decree, that is 25/9/2017. Being agreed by that part of the judgment passed by the learned first appellate court to the extent of directing the defendants who are the applicants herein to pay the amount of rupees 2 lakhs as compensation. The applicant filed an application under section 115 of the Code of Civil Procedure 1908, which before this court, which was registered and numbered as CRP number 3/2018. This court, by an order dated 8/1/2018, issued notice. Thereupon, something is wrong with that order, something.
Date, Lordship. The 17th.
Then thereafter, my lord, on that day, it was paid also.
Thereupon, by an order dated 25/9/2019, the said revision application was withdrawn. Be that as it may, the learned, but this court did not observe anything as regards the filing of the suit, filing of the revision application being in a wrong judicial forum. However, liberty was granted to the appellant to withdraw the revision application and file a regular second appeal. Thereupon, it appears that the instant appeal was filed on 21st of July 2023. From a perusal of the said application, it was an admitted fact that after taking into account the period of limitation, extended period of limitation as provided by the Supreme Court in its order dated 10/1/2022. 10/1/2022. 10/1/2022. In writ petition 3/2020. And also the period during which the revision application was filed, there was a delay of 565 days in preparing the regular second appeal. The reason which have been assigned in the second appeal is that the applicant number 1 was not well, was under treatment at the LGB Regional Institute of Mental Health, Tezpur, being a psychiatric patient, and was as such not in a position to collect the brief from its earlier counsel, late Rupjyoti Bordloi, who was engaged to file the second appeal. It was further mentioned that during that said period, late Rupjyoti Bordloi had expired, and only on 26/2023, the applicant number 1 could collect the file from his junior, one Mr. R. Ali. It is under such circumstances the delay had occasioned. Upon filing of the instant application, notice was issued, and the respondent herein duly appeared by filing a written objection, contesting the application on the ground that the grounds so assiled are not at all sufficient for condoning the delay. At this stage, this court have duly heard the learned counsel appearing on behalf of the petitioner, applicant, Mr. S.K. Ghosh, and Mr. So-and-so appearing on behalf of the respondent. Before further proceeding, this court finds relevant to take note of the recent judgment of the Supreme Court in the case of in so-and-so. In the backdrop of the above, if this court now takes note of the facts involved in the instant case, it would be seen that the documents evidencing that the applicant number 1 was a psychiatric patient are documents which have been collectively enclosed as annexure 3 to 6. A perusal of the said documents clearly show that the applicant number 1 was an outpatient, and he was only prescribed certain medicines. There was no medication. There was no medical. There is no other medical document to show that there has been that the applicant number 1 was incapacitated from filing, for taking steps or doing the day-to-day works. Be that as it may, this court further finds it relevant to take note of that the applicant number 2 and 3, 2, 3, and 4 were very much there, and there is not a single whisper in the application as to why they were not in a position to take appropriate steps for filing of the second appeal. Relevant herein to note that the applicant number 4 is the son of the applicant number 1. This court further finds it also relevant to take note of that the counsel of the applicant, the earlier counsel of the applicant, even assume in this court, under such circumstances, the reasons so assigned in the application, in the opinion of this court, are not sufficient for condoning the delay of 565 days in filing the regular second appeal, for which the instant application stands dismissed. The consequential effect of the dismissal of the instant application is that the accompanying second appeal so filed has become barred by limitation for which the same cannot be entertained.
Your Lordship, as per official data 2/4/24.
Lord, we have appeared all the respondents. I appear on behalf of all the
What was that? What is this?
respondents.
How much? 39. Okay.
Lord,
I
it
hope.
should,
Heard Mr. So-and-so, the learned counsel appearing on behalf.
Lord, it should not be 39. sir.
What?
There are certain discrepancies which I'd like to point out.
What? 39 days? I'm not going to hear anything
Lord,
to
it's
this.
more than 158 days.
300 days, don't say anything. After that, you say something.
Lord, just one point. I'd like to-
Yes.
Lord, paragraph number,
When was the judgment delivered?
my Lord, 23 to 2023, my Lord.
Then?
Then they say, my Lord, they got to know about the passing of the judgment on 29/5. They met with their lawyers, my Lord. Thereafter, my Lord, they met with their counsel in High Court on 17/6. Thereafter, they applied for the copy of the judgment. And they were delivered with the copy of the judgment on 20.
Here, the registry finds it 39 days. Matter ends there. Nothing more.
My Lord, one thing I'd like to just point out.
Judgment delivered on 23/2. Date of filing is on 31/7. And then this is one total 156 days. He gets the benefit of 90 days. Then, whatever may be, for certified copies, he has taken 27 days. And thereby it is 39 days. Then nothing
My
remains.
Lord, just one thing I'd like.
There's nothing more.
My Lord, paragraph 7, my Lord, they had stated that they had filed this instant application on 31/7, my Lord. And the document which they have annexed to support that is of 14/8.
14?
14/8, 14th of August. My Lord,
What?
paragraph 7 at page number 6, my Lord.
What?
My Lord,
No.
at the bottom, the appellant thereafter could proceed to meet his advocate at Guwahati on 25/7, as the appellant could not be prepared with money for spending towards litigation because of their hardship. On 25/7/23, they met with the advocate concerned and handed over the certified copy and the case records for preparation of the memo of appeal to file the second appeal before this honorable court. The advocate for the appellant thereafter took time for preparation of the second appeal till 28/7/23, and the said appeal was filed accordingly on Monday, that is 31/7, my Lord. My Lord, if your Lordship may kindly see, my Lord, the affidavit, my Lord, it has been filed on, and even in the CIS, my Lord, it's 22nd of August 23, my Lord, when this application was filed. And the document which they have annexed to support their contention, my Lord, that the petitioner number 4's mother-in-law was ill, my Lord, that document is dated 14/8, my Lord, Gaon Bura's certificate or something. That's the only thing I like to point out, my Lord, nothing. My Lord, the delay from, even if it is taken, my Lord, from 28/7, my Lord, till 22nd of August, my Lord, 25 to 28 days, my Lord, that has not been happened. That is the only thing.
You see what they did? They filed it with a lot of defects on 31/7. They did not have the stamp paper. They gave only half of the stamp paper. There were so many defects. Condonation petition required delay. They did not file. Ad valorem fee of rupees 14,000, 1,462 to be given, half prepaid. Age of the applicant to be mentioned in the course title and all appellants to put signature in the wakalatnama, not done. Fair copy of the type copy, not done. This was reported on 2/8. Meaning thereby when it is done on 2/8 means 31/7 it has been filed. So that is the report. It was rectified on 24/8. See, this is how they did.
And my lord, the supporting document is of 14.
That is why. No. They didn't file the condonation, na. Condonation was filed on 14/8. You see, the appeal can very well be filed without the condonation. There's no quarrel with that. This is how it has happened. Anyway, this is an application filed under Section 5 of the Limitation Act for condoning the delay of 39 days in preferring the accompanying appeal against the judgment and decree dated 23/2/2023, passed in title appeal number 23/2019. This court have duly taken note of the grounds and reasons which have been stated in the application, and more particularly in paragraph number 4 to 7. The said grounds and reasons, in the opinion of this court, are sufficient for condoning the delay of 39 days in preferring the instant appeal, the accompanying appeal. Accordingly, the delay of 39 days is condoned. I stands disposed. The registry is directed to register the accompanying second appeal and list the matter in the stage of Order 41, Rule 11, where
A copy of the appeal.
a copy of the memo of appeal be served upon Mr. A. Batra during the course of the day.
My lord, our names may be reflected in the
Absolutely no. Why are you appearing? Oh, because of the delay. You keep a watch.
highly obliged.
Back the lordship. I don't think it's file one IM lord.
What is this?
IM lord order 39, rule 1 and 2. In this case, on 8/11/23, notice issued me not order said their name is showing in the cause list me not.
Notice.
Issued me not service complete me not. One Mr. S. Chakraborty.
Hello. Okay. None has appeared on behalf of the respondent on call when the instant application has been taken up. Also, considering the above, this court fixes the matter again on 29/4/2024. It will make clear if the respondent is not represented on that day, the court shall proceed with the passing appropriate orders in the instant application. RSA has been admitted.
Yes, my lord.
But in this case, I have filed an IA for injunction. The RSA was acquitted, my lord, and stay was also granted.
Before my learned friend start, lordship, may it please your lordship. I am on behalf of Mr. H.M.R. Chaudhary. Can it be taken on next week, lordship? Any day, lordship.
What injunction you are asking?
My lord, it was originally suit was for partition. The trial court, after considering the material evidence on record, ascertained the share of each of the parties, and suit was accordingly partly taken. Then they preferred appeal. In appeal, what happened? Entire suit was the what they have prayed. Entire suit was decreed.
Who has the plaintiff?
They are decreed.
The suit was decreed.
The entire suit was decreed
Then
without ascertaining the share.
Then
we filed second appeal.
and second appeal is admitted.
Admitted.
Now you want a status quo.
Instead of
Maintain status quo.
I'm not in this case, Lord.
Okay, none appears. Has the service, his name has been shown, he's not there.
Yes, Lordship, he is out of station,
I
so
can't
he
know.
requested. Lordship.
You have filed a wakalat number?
No, Lord.
No, then don't say anything. None has appeared on here.
Lordship can take it up on Monday, Lordship. On 26th.
In this case, notice has not been issued, na?
Here the counsel for the respondent appeared as a caveat in second appeal.
Okay.
Then I served notice to him. He accepted it.
He accepted this.
Yes.
Okay. He has accepted. On 17/10/2023.
Yes.
Oh, then.
Today is the first time. Lordship.
Okay. So you want no construction
No construction over the vacant land. They are also
over the schedule, which land?
I have mentioned in
You are in possession.
schedule 1. I have mentioned schedule 1 and 2. Over schedule 2 land,
The suit has been decreed.
suit has been declared.
Thereby, it has gone in their favor.
It was got in their favor.
Have you got a stay?
Yes.
The judgment has been stayed.
Stayed.
Now they are trying to disturb your possession.
Not only disturb, they are started.
Come to the
construction.
point.
Yes.
Disturb your possession.
Yes. And I have submitted the document papers also. Annexure 3 of this IA, my lord. They are started construction. So I approached the police authority also. Then it was stayed. Stop the construction.
So the construction has been stopped.
Stop.
And why you are asking not who has constructed in your land?
In the share of the land of the plain, AP land.
Chalo. Heard Mr. S.K. Ghosh, the learned counsel, appearing on behalf of the applicant. None has appeared on behalf of the respondent on call. The learned counsel, appearing on behalf of the applicant, submits that the matter is of great urgency, taking into account that the opposite parties, that in spite of the appeal having been admitted by formulating substantial question of law, and there is a stay to the judgment and decree passed by the learned First Appellate Court, by this court, the respondent herein, the opposite parties herein, are disturbing the possession of the applicant. He expresses great urgency in the matter. This court have duly taken note of that the respondent counsel, who have duly received the copy of the injunction application on 17/10/2023, have not filed any reply to the same. It is also necessary to take note of that the said respondent counsel is not represented. However, for the end of justice, this court is of the opinion that the status of the property is required to be maintained till the next stage, so that the instant application can be taken up for final disposal. Accordingly, this court fixes the matter again on 13th of May 2024. In the meantime, the parties to the instant application are directed to maintain status quo as regards the suit property. Which is the suit property?
My lord, in the injunction petition, I have specifically mentioned the schedule.
Schedule 1 and 2.
Yes. It is within the schedule of the suit.
Huh?
This schedule 1 and 2 is within the schedule of this suit. There are 3 schedules. I have mentioned 2 schedules.
Status quo as regards the possession in respect to the suit property as described in the plaint of the suit. The said injunction order shall be operative till the next stage. Yes.
13 days delay, 22nd April. 13 days delay, 22nd.
What has happened to the other side? Notice.
First happened.
Okay, notice. Returnable by 6 weeks.
Public.
Steps by 7 days. You can lick it, huh?
Yeah, please, Your Lord.
PW, that case, MSCT.
Yes.
Yes.
Can you allow me 2 weeks time? Okay. Lord.
Why?
Because I have to collect some documents from the MSC terminal as well as from the baggage certificate officer.
What?
For payment of money.
You made a false statement before this court and for which this court passed that order. Why? Under whose instructions did you make that false statement?
Lordship, there was another advocate.
Whose instructions did you make the false statement?
Maybe from the department.
Okay. Who is that person? Ask him to be present tomorrow. This can't happen like this. I've given you more than enough time. Matter has been going on from 16 to 2023.
We are ready to make payment. There may be.
Make the payment.
Actually, we have made some payment before the.
I'm not concerned with anything. You are taking this for granted. Ask the officer to be present on this.
Can you
Giving
allow
us
me
the
2 weeks
account.
time?
No, nothing doing. Ask that person to be present in the court on Wednesday because he made a false statement before this court, which made this court, as well as the counsel appearing on behalf of the petitioner, to make believe that that fact exists.
Yes, Lord.
He had played a fraud upon this court. Either he or the counsel who had appeared on behalf of the ASTC. And Mr. Counsel, mind you, this court is not like another court. And it would be very happy enough to not only impose cost upon the managing director, but also put that person behind the bars. It's a serious case of misleading the score.
Right.
Ask him to be present on Monday, Friday, with the calculation, how much they have to pay. List the matter again on. This review application has been filed, seeking review of the order dated
17/11/20.
17/11/2023, passed by this court, whereby the writ petition was disposed of on the belief and assumption on 17/11/2000, seeking review of the order dated 17/11/2023. It is relevant to take note of that this order of 17/11/2023 was passed on the basis of the submission being made by the learned counsel appearing on behalf of the STC, that the only balance remaining to be paid to the petitioner was rupees 45,750, which was to be released to the petitioner, which would be released to the petitioner on or before 30/11/2023. It is on the basis of the said submission, this court accepted the said position and passed and closed the writ petition. At a later point of time, it came to light that the petitioner actually was entitled to
Page 17 of the petition. It is 8,88,577 with interest. Page 17.
was entitled to
Eight
an amount of
in the middle,
8,88,577
577. Is on 25/2/14
as on 25/2/2014,
along with interest.
No, this is interest
No,
plus future interest from 26 to 2014. Thereupon, at the time of the disposal of the writ petition, the entitlement of the petitioner was how much?
Lordship, in the meantime, they deposited 5 lakhs, in during the pendency, 5 lakhs 95,750.
So then minus it, how much?
It comes to, Lordship, from 888, it is to be deducted, your Lordship. It is Lordship, 2,47,027. 2,47,027.
Lordship, there is a confusion. We have paid 11 installment. It comes around 6,91,500.
I'm not on that. Math.
2,47,027 as per that certificate. Beside interest.
As of now, how much you are entitled to?
Lordship, that calculation, interest
Mr.
calculation.
Jain, are you not interested in your matter?
No, Lordship, it is 2,47,000 as per certificate plus interest.
As of now, as on the date on which the proceedings was disposed of, that is on 17/11/2023, how much was your actual entitlement?
Interest part.
Illegal. However, at a later stage, it came to light that the petitioner herein was entitled to much more than the amount which was stated by the learned counsel appearing on behalf of the petitioner, ASTC, on 17/11/2023. It is under such circumstances the review application was filed before this court. When the matter was taken up, this court issued notice on 16/2/2024. Thereupon, on 23/2024, the counsel appeared on behalf of the ASTC and sought for time for filing reply. This court. However, no reply has been filed till date. On the other hand, Mr. GC Bora, appearing on behalf of the ASTC, submits that he requires further 2 weeks' time to obtain instructions. The question which is involved in the instant application is to what is the actual entitlement of the petitioner. And if the entitlement on 17/11/2023 was much more than what was submitted, the order by which the court had closed the writ petition would be an error apparent on the face of the record. Not only that, it would also amount to misleading the court either by the ASTC or at his behest by its counsel. Under such circumstances, this court fixes the matter on 29/4/2024, on which date who is going to be appeared? The managing director of ASTC will be present in the court.
Maybe I'm from, maybe law officer, maybe
Who can appear and say before this court?
law officer, law and claims officer.
Who?
Law and claims officer.
On which date? An authorized officer who is in know of the facts of the case of the ASTC shall be personally present at 10:15 before the court. Along with all details as to what was the outstanding as on 17/11/2023 and when the amount would be, and if more than that, and if outstanding, I don't remember. And with further instruction that if there is any due to be paid to the petitioner as to when the said amount would be paid. List according. Mr. Counsel, be careful. I don't have the habit of putting people behind bars.
May it please your lordship.
And Mr. Jain, you should have come up with your calculations properly. This is not how you do it. Yes, what is this?
Yes, your lordship. It is a review petition before your lordship against the order which I have placed at page 102, your lordship.
Then, what is the review about?
Your lordship justified, but there is a little error.
Where is the error apparent?
It is apparent.
Yes, what is the error apparent?
At page, your lordship, the Indian order, at page 62. The that is the specific. They have 10 adjournment, as my learned counsel has said that there is a 10 adjournment. Yes, it is correct also. But in my attention, there is 11 adjournment. 11 adjournment. But he said 10 adjournment. But in my attention, it is 11 adjournment. So, and the entire, but the date of effective date of adjournment is only 4, your lordship.
The 4 also matter over.
There are the reasons. There is a cause and reasons which I have specifically stated in my revision petition. That is the significance of filing my revision petition. And the why I have filed the revision petition, there is a significance because since 2019, your lordship, it was in my case is at the stage of PWs, and but due to COVID, there is an administrative exigency, and they have
COVID happened only from 15/3/2020 to 28/2/2022.
That the entire dispute arise from 11/5/2022, from 11/5/2022, your lordship,
and at that time there is no COVID.
There is no COVID. There is no COVID. I admit it. So only 4 dates. Effective date of adjournment.
What about the prior to that?
It is
prior to COVID.
Prior to COVID, your
Yes.
lordship.
What was that?
It is allowed by the court below. My petitions has been allowed by the court below, and that is recorded in writing.
Yes. So
only
if it is allowed.
Yes.
Your first date was fixed on 5/8/2019.
2019. Yes.
And then how many dates have gone thereafter?
Yes. There 5/11/19. 5/11/19, then 23/12/19, your lordship.
So 3 days have gone?
Yes.
Then?
I admit it.
Yeah.
That with cause and reason. That
whatever may be, you cannot be granted as per the order 17 rule 1 for more than 3 adjournments. How many adjournments can you grant?
I admit it, your lordship.
What is the review?
I admit it, your lordship. But if your lordship come to the that after the COVID period, your lordship, that 4 dates, where in the 4 dates only for the medical ground, and it is only for the
what medical ground?
Medical ground. My engaged advocate, he's out of station for medical purpose.
How many times for the lawyer? Only once you get it.
Yes, your lordship.
How are you going to get for 4?
Out of station, and he's
even if you see the explanation to order 17 rule 1,
yes,
it says that the lawyer is not there. That cannot be a ground for adjournment.
So
it's a different thing we allow,
yes, and
which I don't.
Yes,
others allow, but this cannot be a ground.
Yes, that cannot be a ground. That so admitted, your lordship.
Then we have admitted everything. Then why the review?
That only the evidence was not lead, your lordship.
Huh?
Evidence was not lead yet, and no evidence was started.
So, how many? If you don't submit your evidence on affidavit, how can it start? It's your mistake.
Yes, yes, I have done wrong. I have admitted your lordship.
You see, first of all, in my case, when a motion comes out here before this court, if I pass an order, normally you will get a relief. In this case, I issued a notice in your case and stayed it. Remember when the matter came up?
Yes, your lordship.
Out of generosity, saying that, okay, there were 4 adjournments, I'll grant you one day with some cost.
Yes, your lordship.
Didn't I tell you when the matter was moved?
Yes, yes.
First.
Yes, your lordship.
Then, when the other side comes up and says that, look here, he has taken 10 adjournments, how do I help you?
But it is entered in the COVID period. Only
Not
by
COVID period. We are prior to COVID 4 days.
Yes, 4 days.
Post-COVID 5
Yes,
days.
5 days, yes, your
That-
lordship.
And the 6th date you did not.
So it is only the remedy lie before your lordship.
You do one thing. Again, out of generosity. You serve a copy of this petition to the other side.
Yes, your lordship.
And then we'll take it up.
Perfect.
List the matter again on 1st of May 2024. May. In the meantime, the counsel for the petitioner is directed to serve a copy of the instant review application upon the counsel who represented the respondents in the revision proceedings. Serve it.
Master.
And we can. Who was that counsel? Mr. Madam, who was the counsel?
Surojit Das.
Huh?
One of the respondents.
Who?
Surojit Das. Of
No,
the
no.
court below.
No, yeah.
Surojit Das. S. Das and there.
No. There's another one. I think A. Ganguly.
Master.
Yes.
My
Mr. Ahmed, the person who is absolutely crisp in his procedure. Tell me.
My lord. In this case, my lord, I filed this petition for stay of the impugned judgment.
Huh?
Impugned judgment and decree.
Stay.
Appeal has been admitted.
Well, why not stay?
Because that was I was not there.
No.
That is
Whether the unregistered sale deed executed to by the father of the plaintiff Hussein Ali in favor of the father are binding upon the plaintiff. So this was admitted. And they have filed now an execution application.
application.
Has been filed. So we take. I'll help it. Which one?
I 399.
Huh?
399.
399. Okay. This is an application under Order 41, Rule 5 of the Code of Civil Procedure for stay of the judgment and decree dated 10/3/2023, passed entitled Appeal Number 9/2022 by the Court of the Civil Judge, Kokrajhar. Full stop. This court have duly taken note of that the accompanying second appeal has already been admitted on 23/8/2023 by formulating a substantial question of law. Full stop. In fact, the appeal has also not been taking into account that the accompanying appeal has been admitted, and in the meantime, an execution proceedings have also been initiated. This court is of the opinion that if a protection is not granted to the petitioner, applicants herein, the filing of the appeal would become infructuous. Filing an admission of the appeal would become infructuous. Accordingly, this court states the impugned judgment and decree dated 10/3/2023, passed entitled Appeal Number 9/2022 by the Court of the Civil Judge Kokrajhar, as well as the title execution case number. What is the number?
1/2020.
1/ where? 1/2023, pending before the Court of the Civil Judge, Junior Division, Kokrajhar, till the disposal of the accompanying appeal, being RSA number 121/2023. I stands disposed. What is the second I?
It may be close, ma'am. It may be I file this for extra of the exhibition code. Separate petition I file.
See,
It is unnecessary.
I told you, na, Mr. J. Ahmed is the crispiest on the question of procedure. He will file for every.
Hello.
Mr. J. Ahmed, the learned counsel appearing on behalf of the applicant, submits that taking into account the order passed in I number C number 399/2024 and the order passed therein, the instant application is not pressed. It is 400. This I stands disposed. RSA records have come.
Okay, but not.
Service is not complete.
Yes.
You are appearing for whom?
I am for the all the respondent. my lord.
One to seven.
The main appeal to the registry shall bring on record the present status of the service upon the respondent and list the matter before this court again on 3rd of June.
Lovely.
Of the status of the service upon the respondent and list the matter on 3rd of.
Hello.
Yes, tell me.
Lordship, this application.
I for what?
This application is for the early hearing, Lordship.
What is the early? What is the reason?
Lordship, I'm going through a financial hardship, Lordship.
Hmm?
I'm going through a financial hardship, Lordship. I run a small cosmetic shop, and therefore, Lordship, in the period of pandemic, I have incurred losses, financial losses.
Hmm.
Thereby, to sustain myself now, so therefore, if this amount, if I succeed in this appeal, Lordship, I might use this decretal amount for my business.
You filed the second appeal.
Lordship.
And that second appeal was admitted. What is exhibit 1?
Exhibit 1, Lordship, the note.
How did you prove it?
Lordship, in the cross examination, they have already accepted that they have signed the note.
List the appeal. It was appeal to the I cannot order you. List this interlocutory application on 1st of August 2024. Along with the regular second appeal. On the same date, an attempt shall be made to take up the regular second appeal for disposal. This court is presently not disposing of this interlocutory application. In as much as in the circumstance, the second appeal cannot be disposed of on the next day, on the date so fixed. The counsel for the applicant shall be at liberty to press the same for fixing another glitch.
Much.
Yes, what is this?
I have filed one IA for impeachment, Lordship. In this case, I am the main defendant, Lordship. Plaintiff filed the suit, Lordship, as main defendant. I have contested, suit was victory, then I have preferred in first appeal, Lordship. First appeal was allowed. The plaintiff preferred regular second appeal, Lordship, but defendant number one was not made for appeal.
So he doesn't want to, you won the case.
Lordship.
Well, very well. He's not challenging your decree in your favor. It is his mistake. Why do you want to make me come and submit out here? Eh?
Plaintiff is my sister. Later on, she may object that you are aware about the.
No, they can't.
Lordship.
You see, he has not challenged it.
Lordship, one submission for you.
Yeah.
As per senior instructions, party has been taken back file from us.
They have regarded the brief, Lordship.
Your name is what?
Kasem Ali, Lordship.
The Kasem Ali has not made them a party.
Lordship.
So he is not, who is the main defendant? You.
I am the main defendant. I have preferred the regular first title appeal, Lordship.
And that appeal was allowed.
Allowed.
So how is this second appeal maintainable?
Already admitted. Lordship. They have made
Admission will
the
happen.
proforma
But how is it maintainable?
They made the proforma respondent as party and the official respondents. Lordship.
How is it maintainable? This can't be maintainable because it is not against that appeal which has been filed by the defendant.
Lord.
And that defendant is not made a party.
Lord.
I think this, we'll pick it up on some other date. Yes, why you are not appearing?
Lordship,
Who's your senior?
A. Alam.
Where is he? Who is he?
Out of decision, Your Honor.
Why?
Oh, Anisul Alam, Lordship. He is talking about Anisul Alam. He has been engaged by Mr. A.T. Sarkar. Anisul Alam informed me that A.T. Sarkar engaged him, Lordship, for the appeal.
Who is A.T. Sarkar?
A.T. Sarkar
Where is my senior? He's my senior.
Then?
Senior instruct me that party has taken back file. Your Honor. So
let this application be remain like this. I won't impede you. The moment I impede you,
Lord.
you will be putting yourself in a big problem.
Lord.
Let me dismiss that appeal on that ground.
That's for eviction of the main defendant, Lordship.
And how can you file an appeal when the appeal has been filed by the main defendant?
Yes.
And that appeal has been allowed, that main defendant is not a party. But if you make yourself a party out here, you are bound by this.
Lordship, genuinely, I want to contest on later on, maybe Lordship during execution, they may take a point that I was aware about.
Execution for what?
Lordship.
They cannot. Therefore, let us keep that application. We kept this matter on another date. And on that date, we will dismiss this. But he will take the advantage of your application. Because his appeal is not maintainable. Hello. List the matter again on.
In that case, Lordship, I will withdraw my application on next date and your Lordship can pass order in the main appeal.
List the matter again on 6th of May. No, we'll have it on 13th May. Matter on 13th of May. On that day, what I propose is I will permit you to withdraw, making an observation that they have not intentionally failed it, so there was no necessity. If that order remains, for all times to come, they can go for even winning this appeal, they would not go for execution. You are safe. And the next day, we are going to put the death knell to the appeal.
Okay.
Yeah.
Application is for substitute.
What is this?
For substituted mode of service, Lordship. Under order by lordship,
You want to take service by how?
paper publication,
Paper publication. Where?
Assam Tribune and Dainik
Upon?
sole respondent,
Where do they stay? In Jorhat?
lordship,
Why you could not find them?
no lordship.
Oh, they are in Guwahati. Last known address will be Guwahati.
Bamuni-Moidan, Guwahati.
So you will be doing
I
it at
stated-
which newspaper?
Assam Tribune and Dainik Janmabhoomi. I have stated in paragraph 2 that I have taken steps, but
Okay.
it returned unserved.
When founded it. Oh, you did not do it earlier.
Lordship, there was
I
some
remember.
lordship,
You asked for another permission,
another permission.
which I said no then. You file another application.
I thought
I remember it. Okay.
order dated 1st April 2024, the RSA lordship. Lordship permitted us to file.
The instant application has been filed for taking a substituted service upon the sole respondent. In as much as by way of the normal course of service, the service, it would not be effective upon the respondent. This court have also taken note of that on an earlier occasion, this court had permitted taking substituted service. But however, as no steps were taken, this court did not permit an extension on the basis of the earlier order. However, liberty was given to the applicants to file an application for which the instant application has been filed. So, taking into account the above, this court fixes the regular second appeal on 22nd of July 2024. The petitioner herein, the applicants herein shall publish the notice in the format shall publish the notice which would be routed through this court, registry of this court, on or before (26) 2024. 20, huh? List accordingly. I stands disposed. Madam, you see, it has to be routed means that there has to be an approval, the format. And then from there you take it. That has to be published.
No.
It is not you what you want. It has to be given there. Okay.
Most of them.
I've given you enough time. Do you need it in the month of August? So that you can do it in the month of July.
No.
Huh?
Because my client was facing some financial difficulties.
Okay, we'll have it on then we have it in the month of on 1st of August, 2nd of August.
Second.
And they would do their publication on or before 1st of July. Okay.
First of most of them.
I am, my lord, directing the respondent to supply the legal heirs method. My lord, on 4/2/2024, when the matter was come up, my senior colleague.
What is this IA for?
My lord, regarding substitution of respondent number 11, Purubala Pal, my lord. On 4/2/2024, my lord.
Who died?
My senior colleague asked me, told me about the death of respondent number 11. So I instructed my client to collect the.
Was
legal-
he appearing for respondent number 11?
No,
all
I
right.
am appearing for 135.
Now, how did you
and
know about
11
11? How did you know about 11? How
I'm
did you know?
representing the 11.
Huh?
I am representing 11.
Then,
Yes,
Yes, ma'am.
now 11 died.
yes.
Right. My
So,
lord- my
when
lord-
did the 11 die?
I have no such information.
No, you have to
Inform me
give
about
that
the death.
because that information you have to give because you were representing. Now, whether he has a legal heir or not, that's another aspect of the matter. But the fact about the death, with the date of the death,
My lord, that although her name was shown as plaintiff number 11, but she was not signatory in the claim. He did not put her signature in the claim. Her name was shown as plaintiff, but he did not put her signature in the claim. She was not signatory in the claim. And my lord, as soon as when I came to know from him about the death of Kurubala Das, I informed my client
No, I have
to
not
collect the legal.
informed her.
Let me
I have not
to
informed
collect
her,
my
because
to
I have
collect the
no
legal
knowledge
hairs.
how I can say.
To collect the legal hairs. My lord, this charged on many occasions, but they could not trace the legal hairs. That's because they have already been shifted from Saparmukh to Moringaon before 1965. And they also procured my lord voter list of Moringaon Legislative Assembly. They also, that also my lord, her name was not found. So my lord, that's why I filed this petition directing the respondent to supply the legal hairs, if any, of Purubala Pal.
My lord,
So that I am able to file.
okay. Now,
my lord,
wait.
I have no information, no instruction about the death of the R11, respondent 11.
But you were representing the R11 earlier.
He told me, my lord.
Madam, wait.
Yes.
You were representing R11. So, if you are representing
She is supplying
R11,
copy to me today.
My lord, I did not find him, my lord. I did not find him. Today I find him.
She is
Supplying
supplying
okay.
copy to me today.
okay. I cannot let you. List the matter again on 13th of May 2024, on which day Mr. R.K. Jain, appearing on behalf of some of the opposite party, shall apply the date of death of the respondent number of the original respondent, the respondent number 11, whom he was representing earlier. Pustak. Pustak. Further to that, as he is also representing the other respondents who are closely related to the respondent number 11, it would be this court would request Mr. R.K. Jain to provide the names of the legal representatives, if any, of Srimati Porula, of the respondent, the deceased respondent number 11, if so possible.
Not
The
request.
first is a
Not
direction.
request, my lord, instruct.
No. That is why. The first is a direction. To give the date is a direction. The second is a request, because that is you are not bound. Yes.
We had a last.